Hey, Richard Lee, can you hear me?
Yes, sir. Can you hear me?
I can, loud and clear. Thank you.
You bet.
See you in a bit.
Good morning, Mr. Hearing Examiner. This is just a microphone test.
Yep, I hear you fine. That's what happens if you leave the Zoom YouTube feed running. I don't know how it happens, but the machine just broadcasts what you just said. There's a slight delay on the YouTube feed. And so you end up with a 5-second delay or roughly that. And then, I don't know why it then automatically plays. I mean, maybe the idea is YouTube is sort of communicating with your PC in a different way than your Zoom audio and mic is. And so it just plays through the sound card, regardless if you want it to or not. It's weird. You'd think they'd figure that out in Zoom. Okay, it's 9 a.m. I think Sydney Beatles is joining us now. And getting a call from our paralegal, so I'm just going to mute this for a second and see what she wants. All right, no one in the waiting room. It's 9:01 a.m. Mr. Lee, ready to be on the record?
Yes.
All right, this is resumption of case number 22-00058, UT PNM's application for grid modernization. This is day 3 of our hearing proceedings. Day 2 was on Wednesday of last week. Day 1 was Tuesday, and today I think we'll comfortably conclude. Just looking at the amount of time requested for the PNM's requested cross of the interveners, it's something like 3.5 hours or something. And along with the other interveners, just totaling up that column. So I think it'll be no problem to get through it all today. Few preliminary things before we return to the proceedings. So I did receive from PNM the responses to bench requests. Supplemental hearing bench request 1, revised numbers to reflect removal of the benefits related to time of day, time of use varying rates. Bench request 2, undepreciated value of PNM's meters, and that would be is it analog meter would be the correct term to utilize for the legacy meters?
No, because some are digital.
Mr. Verheuel, is that right?
I think legacy meters would be the best
Better.
term.
Okay.
It's consistent with phase 1.
And then the third one was
France.
yeah, PNM's past and expected upcoming applications for federal funding for grid mod projects. The only thing I didn't see, Mr. Verheuel, was, and this was a question one of the commissioners had asked about, and that's why I'm going to bring it up again. For Mr. Hawkins, I believe there was a question that's what is the cost of just the communications backbone if we isolate that? And I think I indicated it would, you could interpret the word communication backbone as you saw fit.
Mr. Hearing Examiner, my recollection is that, yes, you did preview that question with a different witness. And then when we got to Mr. Hawkins, I thought you had asked him.
Oh, yes, you're right. And then he directed me, thank you. He directed me to a place in the record that answered that question. And so we did get that on the record. Appreciate that, Mr. Verhule. That's correct. Just going over my notepad to make sure I get everything people ask of me. So, anything else before we turn to the subject of where we left off? And just to satiate my curiosity, and there might be something I see emails. Were we going to go to Mr. Albright? Is that where we were? Mr. Cervantes was testifying. Yes. Did we finish, Mr. Cervantes?
We did.
Finished?
We did. PNM's understanding is that the next witness up would be Mr. Morgan, our final
Okay.
witness or direct testimony. And I don't know if you were going to go here, Mr. Hearing Examiner, but maybe this is the right time. What PNM would propose procedurally this morning is that after Mr. Morgan, we bring up witnesses to introduce the 3 bench requests.
Sure.
Okay. And again, as a preview, we're actually planning to have a 2-person panel for bench request 1. That would be Mr. Shields in terms of the actual cost benefit analysis that was run. But to the extent that there are questions about time of day or time of use rates, we would ask for Mr. Settlage to be on a panel with him as well. And they are thousands of miles apart from each other, but they are both planning to appear at the same time.
Sure. And I see Commissioner Ellison has joined us, and partly I think it's important that his schedule be accommodated by Commissioner Ellison. Are you able to? There you are.
Hi, good morning. Yes, I'm here.
Is that time frame going to work for you? If we, did you say, Mr. Verhule, to do Mr. Morgan and then go back to the bench requests?
Yes, and then do the bench requests in order 1, 2, 3, or whatever suits yourself or Commissioner Ellison.
Commissioner Ellison, Mr. Morgan, who's last PNM witness, there's a total of 60 minutes of cross requested of him. So we would go for an hour and then take the bench requests, and then I'm assuming you'll have some follow-up questions about some of the subjects that were the responses to the bench requests.
I may. I'll have to see when we get there.
But if you're all right to be with us for the next hour or so, or
Yes.
longer than that, but okay.
Yes,
Just want to check.
fine.
Hearing examiner, just for the sake
yes, Ms. Barrett.
sir. For the sake of efficiency, I just wanted to let you know that the NMDOJ is going to waive the remaining cross that we had planned for Mr. Morgan, so it will be even a slightly shorter amount of time.
Okay. I'll take Mr. Albright, and then I'll go to Mr. Bruno.
Yes, sir. Just I wanted to move some time to Mr. Morgan, if I might. I think I was down to 15 minutes for Mr. Morgan, and I'd like to move. And I was down to 10 for Mr. Kenny. I'd like to move 5 minutes from Mr. Kenny to Mr. Morgan, which should give me 20 minutes for Mr. Morgan.
Okay. And 5 minutes for Mr. Kenny.
Correct.
Okay. That's
Mr. Hearing
reflected.
Examiner?
Yes, Mr. Verhule.
I'm sorry, I feel like I'm playing the cop on this. My notes indicate that Bernalillo County was already down to 10 minutes for Mr. Morgan. They had shifted time.
I had that note too, and I appreciate you paying attention, Mr. Verhule. I wasn't going to flip Mr. Albright on that, but I think he's correct, Mr. Albright. Mr. Verhule, do you object? I mean, I was going to let it slide.
It's your hearing, Mr. Hearing Examiner. No objection.
And I can move 5 minutes from staff witness Tupler. That reduces that down to 5, which is, I think, all I need for staff. And that would then add another 5 minutes to Mr. Morgan.
Yeah, and that's fine, Mr. Verhul. I appreciate that. Thank you for. I don't think it's correct that you all should be diligent about paying attention to time, and I don't know, just being the taskmaster is important, but I also just feel like sometimes as well it's important just to let people ask whatever questions they want, get the full record, decide on the substance, right? So, anyways, all right. So Mr. Albright, say it again. You're now with how many? So for your 20 for Morgan,
20 for Morgan, 5 for
5
Mr.
for
Kinney,
and 5
for
Tupler.
Mr. Tupler. Correct.
Okay.
And my apologies. I had various line throughs and markups there on the time. So
No, that's
my-
fine. No, I'm sure it wasn't intentional. I completely understand. Thank you. Okay, I think now Mr. Bruno or Mr. Borman. Let's hear from Mr. Borman first, then Mr. Bruno.
I just wanted to inform Mr. Hearing Examiner, Mr. Tupler is staff's witness and he is available all day today. I know you indicated that we intend and expect to finish today, but if we do not, he would be available until noon tomorrow.
Okay, yeah, no, our intention is to. If we don't finish today, I don't know what I'll do. I'll be as frustrated as all of you.
Understood. I just wanted you to be aware of that fact.
Sure. Thank you. Anything further before Mr. Bruno? Okay, Mr. Bruno.
Good morning. I believe it was said that Mr. Kyle Sanders would be available this morning for cross-examination. Is that true?
My understanding, and you can correct me if I'm wrong, Mr. Verhul, is that Mr. Sanders will appear to provide responses on the balances for the undepreciated legacy meters, and will sit for questioning on that subject. Is that right, Mr. Verhul?
Yes.
Mr. Bruno, does that answer your question?
So I'm just wondering if there's going to be time for cross-examination for each of those bench requests.
The scope of questioning in circumstances like the present, where a witness appears in response to bench requests, is limited to the scope of the hearing examiner or commission questioning. So yes, Mr. Bruno, you do have a right to some degree of questioning on the subjects that we raise, either myself or Commissioner Ellison, but Mr. Sanders is not appearing today to be cross-examined on every and any subject.
Thank you. I do have some time.
I just want to make sure, PNM, that's acceptable to you, that response?
Yes, Mr. Hearing Examiner, thank you. And with respect to Mr. Sanders, he will be available to appear this morning, but I've just been made aware that he's on an earnings call this morning, and so his availability will start sometime in the ballpark of 10:30. So if we have to flip the order of the bench requests to accommodate that,
Sure.
and make him available, that may happen.
And we could take intervener witnesses too if we have to, just shuffle stuff around to get everything accomplished.
Thank you.
Yeah. All right, Mr. Bruno, were you saying something further?
I was just saying that I do have some time scheduled for staff witness, but I think I would might want to use some of that time to cross-examine on the bench requests, depending on what's said in those bench requests. You know,
Okay.
based on what I've read in the bench requests, actually, I do have some questions.
Okay. We'll cross that bridge when we get there, Mr. Bruno.
Thank you.
Anything else? Okay, we will now turn to PNM's next witness. Mr. Verhul, you can call your next witness, please.
Thank you. PNM calls Eric Morgan.
Good morning, Mr. Morgan, and Mr. Court Reporter, if you could swear the witness in, please.
Mr. Lee, you're muted.
Mr. Morgan, do you solemnly swear the testimony you're about to give in the matter and opinion should be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Good morning, Mr. Morgan. Please state your name and your job title.
Yes, good morning. My name is Eric Morgan. I am the Director of Customer Operations at PNM.
Do you have before you what has been labeled PNM Supplemental Hearing Exhibit 12? This is your supplemental testimony in support of CBA.
Yes.
Was this prepared by you or under your supervision?
Yes, it was.
Is it a true and accurate account to the best of your knowledge?
Yes, it is.
Are there any additions or corrections to it?
No, there are not.
If I asked you the same questions today, would the answers be the same?
Yes.
Mr. Hearing Examiner, I would move PNM Supplemental Hearing Exhibit number 12 into evidence.
Any objections? PNM Supplemental Hearing Exhibit 12 is admitted.
I tender the witness for cross-examination.
It appears, Ms. Barrett, again, my notes on this indicate that we got, you guys utilized all your time with Mr. Morgan. By you guys, I'm referring to the Department of Justice, that you all used your time up, unless your record reflects something else. Is that the case?
My records say the same thing, and even if it were something different, we would waive whatever was left for Mr. Morgan. Our questions have been answered.
Thank you. Mr. DeSayan, CCAE, looks like they put 10 minutes down for Mr. Morgan.
Yes, Mr. Hearing Examiner, no questions. Thank you.
Okay, Ms. Beatles, WRA, I see 10 minutes.
Cannot hear you, Miss Beadle. We cannot hear you, Miss Beatles.
Well, okay, we can just do this maybe. Since she's having technical difficulties, she appears to be saying no questions, and now Ms. Beatles is also nodding her head, so she's waiving any questions she would have had with Mr. Morgan. Okay, and that brings us to Bernalillo County and Mr. Albright, and 20 minutes is what you requested.
Yes, sir, I believe that's correct. Good morning, Mr. Morgan.
Good morning, Mr. Albright.
I think we have met each other before in this venue, and I'm here on behalf of Bernalillo County today. My questions are going to focus on your supplemental testimony that was filed. So I'd like to begin by, if you'll turn to page 2. In lines 4, basically the first paragraph there, lines 4 through 10. You state at line 6 that you identified the revenue that PNM will realize from the one-time and monthly fees charged to customers who choose to opt out of advanced metering infrastructure. And then it goes on for a while. Do you see that language?
Yes, I have it in front of me.
Okay. What is the one-time and monthly fee that's going to be charged to customers who opt out?
Objection.
What's the basis?
Mr. Hearing Examiner, this was, all these costs were covered in phase 1. I think witnesses have been asked ad nauseum about certain costs, and every witness has indicated they are the same as in phase 1. And I certainly recall Mr. Morgan being cross-examined extensively on these costs in the phase 1 hearing.
I do as well. Yeah. Mr. Albright?
I would just say that, it talks about the fees have to offset one-time costs for meter changes, assuming opt-out occurs prior to AMI meter swap. And we've had a lot of testimony with regard to the the current opt-in and opt-out and what impact that's going to have with regard to the AMI over the long haul.
I'll sustain the objection.
Do you have data with respect to the lifespan of the proposed smart meters? Is for the 20 years that's projected as part of the cost benefit analysis?
Objection.
Is it the same basis, Mr. Verheuel?
It is.
I would respond that I think it's relevant to the independent evaluation of the manufacturer's estimate, since these are new meters.
I'll sustain the objection.
Mr. Morgan, does PNM have any experience providing installation and repair services to the smart meters that are proposed for the grid mod plan with regard to training or special equipment that would be part of the CBA?
Just so I understand the question, Mr. Albright, you're asking, does PNM personnel have experience in exchanging these types of meters?
Correct.
Objection.
Mr. Albright? Well, sorry, Mr. Verheuel, is it the same basis for the objection that we've heard?
It is the same basis.
Okay, and Mr. Albright?
I would respond that I think this is relevant to the CBA because, you know, what has PNM done with regard to calculating the cost of these as part of the CBA benefit? And I don't think that's in the record yet.
Okay, yeah, overruled on that one. You can answer that question, Mr. Morgan. Do you understand his question, sir?
I do believe so, hearing examiner.
Okay, go ahead.
In regards to PNM's experience in exchanging these types of meters, we currently don't have these type of meters currently today. So whether or not that particular PNM classification has the experience to exchange AMI smart meters, I cannot say yes or no to that question. In our initial filing, our first filing, we are proposing that we have a contractor do these installs. So those folks will have the experience, I think, that you're inquiring about. I cannot speak for PNM.
Okay, well, with just as a follow-on on that same question, though, since these are new meters, and as you say, you're going to have a mechanism in place to install them, have the costs of training PNM employees been included as part of the cost-benefit analysis? Do you have any estimation on what the training costs might be for these people to replace them, for PNM people to replace them?
Well, and Mr. Morgan, before I'll pause your time, Mr. Albright, and I want to hear the answer to that question. But as a preliminary matter, Mr. Morgan, if you don't know the answer to the question, it's fine. The question I'm going to ask you now is what I'm saying. Am I wrong to assume that the meter socket, is there a significant process that's somehow different for these than others? Do you know?
I think I recall witness Hawkins speaking to that. The socket itself does not change. So it's simply swapping out one meter with a AMI meter.
Right.
Very similar, no change.
Okay, go ahead.
To the second part of your question, Mr. Albright, I don't have the answer to that as to if the cost for training that personnel specifically on these meters is incorporated in the BCA.
And related, I mean, just to follow on, by paying outside contractors to install, is that what you're saying? Has that cost been included with regard to the cost benefit analysis, and how would that compare if you had to do this in-house with PNM people?
Objection.
What's the basis?
Same basis as before. This was covered extensively in phase one. The costs are included.
I'm asking if it was included in the cost benefit analysis.
Okay, I'll allow the question. I'll overrule the objection. Go ahead, Mr. Morgan. You can answer if you know the answer.
Mr. Albright, can you repeat the question?
Yes, whether or not there was any analysis done with regard to the cost incurred by hiring outside contractors as opposed to the cost incurred by PNM to train its own personnel. Has that been factored into the cost benefit analysis?
I don't believe so, Mr. Albright.
Okay. Do you know if any of the projected costs the PNM developed and presented before have changed for 2023 or 2024 since the initial portion of this hearing was done?
Sorry, repeat the question?
Yeah, let me rephrase.
There's a
In
lot
phase
of-
one, there was extensive discussion about the costs that were incurred, would be incurred with regard to the installation of the meters and so forth. Has any of that changed since phase one, and has that been factored into the CBR, cost benefit analysis?
We have not submitted for repricing, so that has not been factored in.
Okay.
It's the cost from the initial filing.
One of the factors in the CBR, if you look at page 3, states that you used at lines 3 through 7, that you use costs specific to each of the pay levels based on employee classifications of the required personnel. Do you see that language at lines 3 and 4?
Yes, I do.
Okay, how was that determined, and how is that reflected in the CBR or in the cost or in the benefit cost analysis?
And just for clarity of the record, Mr. Albright, you keep saying CBR. There's benefit cost ratios, BCRs, right? Which is we see individual, like, but the BCA is the CBA.
I'm sorry.
That's all right.
I misspoke. Yes, it should be either cost benefit analysis or benefit cost analysis.
And then the BCRs, the cost benefit ratios, I think are the numbers that we get at the end, which is if it's greater than 1, then it's, ultimately savings for the customers. Under 1, it's expenses. That's my understanding anyway.
Understand. And I would concur with that.
Okay, just wanted to clarify for the record. That's all.
So back to the question with regard to the cost specific to each of the pay levels that you referenced there, how have those been incorporated, or where have those been incorporated in the cost benefit analysis?
I don't have the BCR in front of me, but this would be the cost that would be, because of this classification, the meter readers, specifically that reduction in that cost. I think it's under employee meter read operation, I think is where it might be listed in the CBA.
And that would be of benefit to PNM, correct? As part of the cost benefit analysis, that would be a benefit to PNM.
I think it's an overall benefit to the entire grid modernization filing, but not solely just PNM. It is a reduction in personnel for us, yes.
Which in turn benefits the customer through lower expenses. Right.
Thank you.
On page 3, between lines 13 through 16, you state the main reason is that well, actually back up to 12. Specifically, costs are approximately 15% higher than identified in the previous filing. Do you see that language?
Yes,
And when you say previous filing, what are you referring to there?
our filing from October of 22.
Okay.
Mhm.
Have you seen any additional increase from the 15% since phase one of the hearing that needs to be factored into the cost benefit analysis at this point?
Objection.
What's the basis?
Stating facts not in evidence, the question asserts that some costs need to be factored into the cost benefit analysis when the testimony clearly states that the 15% increase was not factored into the cost benefit analysis.
Just re-reviewing the question. All right, so Mr. Albright, can you, I'll sustain that objection. Can you ask whatever question you're trying to ask?
Yeah, let me rephrase the question. You state that costs are approximately 15% higher than identified in the previous filing. Do you see that language in lines 12 through 13?
Correct.
Okay. What I'm trying to determine is since then, since it says these increased costs are based on actual costs incurred from January through July 2023. And do you see that?
Yes,
Okay, so that refers to the 15%, correct?
correct. That's not included in the cost benefit analysis.
And my question is, has there been any other increase since that time that you're aware of that should be included in the cost benefit analysis?
Objection. Same basis.
Overruled. Go ahead, Mr. Morgan.
I'm not aware if there's been any additional increased costs since then. But again, it's cost at that time, and in general, cost does continue to increase. So
And let me just pause, Mr. Albright's time. Mr. Morgan, I just want to understand, just because I think I understand what Mr. Albright's asking, but I just want to make sure I'm clear on this. So what you're saying here in the testimony is you guys PNM filed this application. You said it was 2022. I just want to double check that. Might have been 2023, but I could be wrong. No, it's 2022.
And it was based on 21.
Yes, and so then effectively, since the time of that filing, we all are aware inflation has happened and costs for everything goes up. And then you did the BCA at a later date, November of 2023. And so your testimony is that those inflationary pressures are or are not reflected in the BCA?
Are not.
Okay. Okay, that's all I need to hear. Thank you.
Thank you, Mr. Morgan, and my apologies for not having phrased that more succinctly, but that was what I was trying to determine. Has the reduction in meter reading exceptions leading to a reduction in headcount been factored into the CBA?
A reduction to headcount for exceptions or for meter reading? I just want to clarify that.
Well, page 3, lines 11 to 12, you state that PNM is projecting a 95% reduction in the volume of meter reading exceptions to determine the expected AMI savings. And so my question is, will the reduction in meter reading exception lead to a reduction in headcount? And has that been factored into the CB or the cost benefit analysis?
I'm sorry, Mr. Albright. I'm looking at my supplemental testimony. And
I'm sorry. That was actually a note I had. Just strike that from that question from the record. At page 3, bouncing back and forth here. At page 3, lines 4 to 7, state that meters will reduce work-related injuries. Can you identify what impact that has had on the cost-benefit analysis, or where that has been included in the cost-benefit analysis?
Where exactly it's in the cost-benefit analysis, it was a data point in which the collaborative efforts with Black and Veatch that I provided to them to incorporate into the cost-benefit.
Do you know how they incorporated that, or what they did, or you just provided the data?
I'm not 100% sure, but I'm certain it probably had to do more with a reduction of cost, because those types of incidents would be eliminated with an AMI smart meter infrastructure.
Do you know?
Sorry, Mr. Ballard, before you, I don't mean to cut you off, but I just want to ask that the incidents that you're referring to, Mr. Morgan, I saw that testimony as well, and I'm assuming these are sort of small scale injuries that, I mean, it's not as if these are major issues. Is that right?
Maybe not so much. The injuries are minor, but I think
Yeah.
the amount of cost associated with vehicle damage, whether
Okay.
that's our vehicle, our driver at fault, or another driver, obviously we try to recover if they're insured, but that does tend to drive most of that cost is the vehicle incidents.
Vehicle, okay.
Mhm.
I was imagining the dog bite and the post office scenario, but that's probably not accurate because you guys are driving around with the meters and they can be read that way. Is that right? The standard meters, or does the guy have to get out of the car and get close to the house? How does that work?
Yeah, physically must be what I would say touch the meter in most
Okay.
cases to be able to read it, but to get to a location, our folks are driving PNM vehicles or vehicles for company use.
And auto vehicle accidents are the principal expense that you're describing.
That is correct.
Okay, great, thanks.
So, in providing this information to Black and Veatch, did you look at injuries in other jurisdictions to see what impact it might have on cost-benefit analysis, or did it just go into the black box that Black and Veatch was putting together?
We did not look at other utilities. Like I said, it was a collaborative effort based on Black and Veatch's experience in pulling together a cost-benefit analysis, and this was something they had asked us to provide, and we had that information available.
So is there any data, are you aware of any data that would actually show that there were reduced work-related injuries in other jurisdictions that would contribute to the cost-benefit analysis to the CBA?
I am not aware.
Okay. At page 3, line 12, you state, yes, meter reading costs have increased. Well, we've already covered that. I'm sorry. We've already covered that with regard to the 15% higher.
So just, and then to put two concepts together, Mr. Morgan, is the 15% increase reflective sort of fuel, insurance costs, automobile maintenance? Is that where that's coming from?
Yeah, and I would also include wages as part of that as well. Mhm.
Okay.
So I was going to ask if that included increased labor costs, and have the increase in labor costs been factored into the CBA or in the data that was provided at Black and Veatch?
Well, in our CBA, we used the cost from 2021 through the first 10 years. I believe in the Black and Veatch documents, there possibly, I cannot confirm, so I'm not going to say yes or no whether or not they use the increase or not.
But you presume that the number of employees would remain the same, correct? In the data that was provided to Black and Veatch?
That is correct.
Got about a minute, Mr. Albright.
Looking through my notes now, Mr. Hearing Examiner, thank you. Mr. Morgan, I believe that's all the questions I have right now. Thank you very much for your explanation and answered the question. I appreciate your effort. Thank you.
Welcome.
All right, Mr. Baker requested 5 minutes, Mr. Morgan.
Thank you, Mr. Hearing Examiner. Mr. Morgan, good morning.
Good morning, Mr. Baker.
I wanted to ask if you were the person giving the information, the cost information that was used in the bench request, or should I save that till later? Basically, okay, let me start over. So were you the one giving the information that was used in the supplemental bench requests, which were turned in this morning?
Objection.
Go ahead, Mr. Vigil. What's the basis?
The basis is this is not part of Mr. Morgan's testimony. If Mr. Baker wants to cross-examine witnesses on the bench requests, I believe we're going to do that after Mr. Morgan is done with the witnesses who are going to support those bench request responses.
Well, Mr. Verheuel, my understanding is Mr. Morgan is not one of those witnesses.
That is correct.
That's why I'm asking it now, because he's the guy who supplies all the data, right? I'm just trying to get at whether or not, because I have some specific questions about what data is either included or not included in that supplemental bench request response. And so I wanted to ask the witness while he's available, whether or not he knows that the data is in there or not in there.
Well, Mr. Morgan's not one of those witnesses, Mr. Baker. So you can infer that asking him questions of this nature is not going to yield fruit, which would suggest we should just carry on.
Okay, I will save my questions for after Mr. Morgan, when we're talking about the supplemental responses.
Okay, Mr. Verheuel, any redirect with Mr. Morgan?
Just one topic. This should be fairly brief.
Sure.
Mr. Morgan, do you recall when you were being asked about avoided costs related to meter installations and replacements?
Yes, I do.
My recollection, you can correct me if I'm wrong, my recollection is you were asked if those costs had gone up. Well, if they had gone up, I suppose, since our original filing. Do you remember that?
Yes, I do.
Do you have any data indicating the costs have gone up or not?
I don't have any specific data, but when you look at just overall of operating my particular part of the business, costs have increased. So I would expect that the installation cost probably has gone up as well.
Because those costs, once AMI is implemented, those installation and replacement, well, if those costs have gone up, but the cost benefit analysis that we filed uses the older, lower costs, does that indicate that to you that the cost benefit analysis is a more conservative cost benefit analysis in that it's using lower costs?
Because our initial filing is at a lower cost and costs have increased, that would mean that the BCR benefit cost would be, the original filing was conservative, is what I would say. So there are greater costs, so it would be more benefit to our customers.
Okay, thank you. No further questions.
Welcome.
All right, Mr. Morgan, thank you. I have no questions for you, sir. I appreciate you appearing today and Mr. Ellison, Commissioner Ellison, you've appeared on screen. If you wanted to ask Mr. Morgan questions, please go ahead.
Yes, thank you very much, Mr. Hearing Examiner. Mr. Morgan, good morning.
Good morning, Commissioner Ellison.
Pleasure to meet you virtually. I'd just like to ask a few questions. I understand you're the manager for meter reading and collection at PNM, is that correct?
My role has expanded recently, but at the time when the initial filing was made, I was managing the meter reading operations, yes.
Okay. The collection side of that, does that go beyond the meter reading?
Yes, it's a different classification that I have oversight for, bill collections.
I see. Could you briefly describe that collection function?
As it is today, it is for our customers who are delinquent, greater than 45 days on previously billed charges. They attempt to, well, through our normal ruling process, after all of that has completed, they will go out to collect on a customer's account or disconnect for non-payment.
Okay. Are there, in your view, are there benefits of having meter readers in the field that go beyond the reading of meters?
I think to some degree, Commissioner Ellison, that they actually do more than read meters today. I would say that, eyes on meters in regards to potential energy theft, hazards that may exist, I would say is within their scope, but not the primary function of their job.
And so are they of help in system maintenance type of issues, such as, if they notice a pole that's leaning over or a transformer that's buzzing or a meter that appears damaged, might that occur? Might they report that to others at PNM?
Yes, if they were to come across something of that nature, they would report it.
Okay. And could there also be some customer relations benefit from having meter readers in the field?
I think they're an initial contact source when they do come in contact with customers, but usually that conversation is very limited and it's redirected to our contact center for assistance or guidance.
I see. I guess I was wondering if, perhaps the meter reader may be, the only PNM person that a customer might normally come into contact with. I mean, a live person that, that they would see from PNM, the meter reader might be the only one they come into contact with. Would you agree that may be true?
Yes, I would agree that would be true considering how we perform our work, that might be the only PNM personnel they come in contact with.
Okay. So I guess, I'm wondering if this plan is approved and we would see a very large reduction in the number of meter readers in the field, correct?
Correct.
And some of these other benefits of having meter readers in the field, will they be handled otherwise, or could there be a service that's not performed?
We just haven't gotten that far along, Commissioner Ellison, in regards to design and planning. So that may be an opportunity for us to try to develop some type of what I would, in your scenario, eyes
Right.
for those type of opportunities.
Right. The monthly opt-out fee, is it your understanding that it's designed to reflect 100% of those costs that people opting out would be imposing?
It was the cost of service that we ran based on that personnel performing that work. So I think to answer your question, is it 100% of the cost to perform that work? I would say yes. It's 100% of what it would cost to read those meters for opt-outs.
Okay. Would you agree that how those, I guess, how those costs are apportioned seems to be a policy decision? In other words, there could be valid reasons for not wanting to assess 100% of those costs to the individuals who are opting out.
I'm sorry, Commissioner Ellis, could you repeat the question for me?
Sure. Yeah, I guess I'm asking, in your view, would you agree that there could be valid reasons for not requiring those who are opting out to pay for 100% of the costs of the meter readers that are required to read their meters?
I don't know if I'm qualified to answer that yes, if there are valid reasons. I'm just trying to think of our cost today and our cost of service, and if there's anything incorporated in there that's for valid reasons for it to be reduced.
Sure. For example, if they are eyes in the field, if they are, reporting maintenance issues, if there are other things besides just meter reading, then perhaps that could be a reason for saying that, gee, we might not want to assess 100% of the costs of that labor to only those individuals who are opting out.
I think like what we provided was a proposed and it's an estimate. So I think, all factors would need to be considered when we do get to that final cost of that service.
Right. How many people are currently employed as meter readers?
93 statewide.
I see. Okay, that's and I know you had this discussion with Mr. Albright. Are you forecasting any net reduction in the amount of labor or not?
I think in that classification, that work that's being performed would be a reduction, but we also have in our filing that it is a 100% redeployment of resources for anyone that is currently in a meter reading position. So there are no layoffs in regards to the meter readers.
Right. Okay. And your current meters, how many of them would you say are digital as opposed to analog? Or what percent?
I couldn't even give you a percentage, Mr. Ellison, in regards to what's digital and legacy mechanical dial meters.
Would the digital primarily be on commercial and industrial customers?
No, sir. We have digital readings for residential, small commercial as well.
I see. And do you currently have a policy of if a meter fails, you replace it with a digital meter?
There's no policy as to what type of meter. It's really what the manufacturer is providing us. And to my knowledge, I believe the vendors that we are using, that's the design manufactured meter, which are digitals.
So the newer meters tend to be digital.
Primarily digital. Correct.
Okay. And the larger customers, commercial, industrial, would you say they're primarily digital, or that your intention is for them to be digital, or not necessarily?
I'm not going to pretend to be a meter expert, but because of the multiple registers that exist on those type of meters, there more than likely will be it's a digital meter.
Okay. And can you read the digital meters through drive-by largely? Are they pinging out a signal that can be picked up by someone in a truck?
For the large customer, general?
Just anyone with the digital meter.
Oh, just digital, okay. Our single register meters do have the ability for drive-by functionality, or we don't even have a drive-by functionality today, Commissioner Ellison. It's actually a walk-by functionality. So those folks have to be within about 100 yards of the meter itself. And it's sprinkled in with the manually read meters. As you start to scale up the meter type, those meters are not functional as a walk-by or drive-by. They must be physically touched and the data pulled off of the meter.
I see. So even the digital meters you're putting in, you have to physically access them. You can't just be, within some distance of them.
Not all of them. It's just a feature that is available on digital meters today.
Okay. But you're not able to really estimate what percentage of say the residential customers might have these digital meters.
If I were to guess, I'd say less than 10% have some form of a.
And the analog meters obviously are not going to have any functionality like that with
There are some old legacy that have the module in it for walk-by.
They do. Okay.
Yes.
Okay. Then, I guess, could you estimate what percentage might have that walk-by module?
On the legacy?
On the legacy.
I wouldn't know the percentage that are legacy walk-by.
Okay.
So Morgan, do you know the technology that's utilized for the walk-by? What are they? How does that communicate with the device that the reader would be holding? It's like cellular devices, or do you know?
Low radio transmission.
Okay.
RF. Very small, very light.
It would ping out a signal every few seconds or something like that, correct?
We have to call for it today.
Okay.
We have to call for it.
Okay. That's great. Thank you, Mr. Morgan. I appreciate it. That's all the questions I have.
Okay. Mr. Verhul, did you have any follow-up questions based on Commissioner Ellison's questions?
Yes, again, very briefly, if that's okay.
That's fine. Go ahead.
Mr. Morgan, you recall being asked by the commissioner if meter readers, if they can physically observe damage that could lead to outages. Do you remember that?
Yes, I do.
Okay. Is it your understanding that if AMI and Flizzr are approved and rolled out, that those will automatically detect outages?
Yes, information will be relayed back to PNM without us physically having to be at the property.
Okay. And in terms of PNM personnel actually out in the field, observing things, interacting with the public, is it your understanding that PNM also has line crews and service trucks that roll today for various reasons unrelated to meter reading?
Yes, we do.
Okay. That's all my questions. Thank you.
Thank you. All right, Mr. Morgan, appreciate your time today. I thank you for participation, and you're excused.
Thank you.
It's 10 o'clock now, and before we get into the bench requests and what that will involve, I think it's prudent for us to take our break, give our court reporter a moment. Go ahead, Mr. Verheul.
Before we go on our break, my regulatory director asked if I think we need permission to upload these bench request responses to Dropbox.
Don't worry about that. I have them. I will see that they're provided to Mr. Lee. He provides us the full transcript of the record and everything at the end.
Thank you.
Yeah. I can put them in Dropbox too, just for the edification of the parties as well. But I know I have them also. I'll just facilitate that transfer on my end. I think that'll be the least confusing way. Anything else before the break, Mr. Bruno?
Mr. Hearing Examiner, it was told to me that last night a commenter tried to make a written comment into the record and that the email bounced. Do you have any knowledge of any issue like that?
The commenter provided an emailed comment to the PRC records department.
Yes.
And that message to the records department bounced, is what you're indicating?
Yes.
That shouldn't happen. The only thing I can think is to verify that the address is correct. And I can tell you what it is if you'd like.
I did verify that, sir.
You did? Okay. Well, I can follow up with the records department and inquire whether they received a comment. And if not, then I will just figure out how to get it.
Thank you.
Thank you. All right, we'll go on our break now. We'll be back at it's 10 exactly, right? Yeah, roughly 10:15. See you in a bit. Okay, it's 10:15. Mr. Lee, you ready? Back on the
Yes.
record. Great. All right, if you turn from our break, and now we're going to go through the process of admitting or working with PNM to admit the supplemental with the answers to the bench request. So, Mr. Verhule, how do you proceed? How do you advise we proceed here?
I would like to, or between Ms. Terwilliger and I, we would like to simply call the witnesses, introduce the exhibit, ask them the normal set of questions, and then tender them for any cross-examination, if that's okay.
Sounds great. Go
Wonderful.
ahead, sir.
Thank you. At this time, PNM calls Jim Shields and Michael Setledge, or recalls them, I should say.
Now, Mr. Shields and Mr. Setledge, our court reporter already swore you in during earlier stages of this proceeding where you provided your testimonies, and you both understand that you're still under oath as you testify here today.
Yes.
Yes. And I'm going to ask these questions of witness Shields. Mr. Setledge is here solely for any questions regarding the time of day or time of use rates themselves or the rate design. So, Mr. Shields, we've already got your name and your job title in the record. So, do you have before you what has been labeled PNM Supplemental Hearing Exhibit 29? This is PNM's response to the first supplemental hearing bench request.
I do.
Was this prepared by you or under your supervision?
It was.
Is it a true and accurate account to the best of your knowledge?
Yes.
Are there any additions or corrections to it?
No.
If I asked you the same questions today, would the answers be the same?
Yes.
Mr. Hearing Examiner, I move to admit PNM Exhibit 29.
And just for clarification, because the copies I received didn't have that numbering at the time, but this is that document, correct?
It is, sir. We've ordered them 29, 30, 31 in the same order as the bench requests.
Great. 29, 30. All right. I will stop share. Are there any objections to the admission of supplemental hearing exhibit 29, which is the bench request to the first supplemental bench request? Answer to the first bench request. Tried those words. Any objections from any party? Mr. Bruno, you raise your hand. Yeah, you're muted, sir.
Sorry about that. Can we have the cross-examination before we admit them into evidence?
Well, I mean, these answers are in response to questions that I asked and the commission asked. So, no, we can do the cross exam after it's admitted because the commission wants these answers on the record. And if we have doubts about the veracity of the stuff there, you can demonstrate as much through whatever questioning you wish. Any other objections? All right, so PNM Supplemental Hearing Exhibit 29, which is entitled PNM's Response to First Supplemental Hearing Bench Request made on April 24th, 2024, is admitted.
Tender the witnesses for cross-examination.
Commissioner Ellison, are you there?
Yes, I am.
Do you have any questions at this point for Mr. Shields that you'd like to ask?
Not at this moment, thank you.
Okay, I'll turn to the interveners for cross to the extent to which there is any based on the response to the bench request. And my understanding is, Mr. Bruno, you have some questions you'd like to ask? You're muted, Mr. Bruno.
I'm sorry. Yeah, I see language in one of the responses, and I don't know how efficiently I can find the line, but it says that there's the purpose of time of use billing is so that customers will shift their usage. And I just I want to ask again if there's evidence that they will actually shift their usage as opposed to just cut back their peak usage.
Objection.
What's the basis?
Asked and answered during cross-examination of prior witnesses.
Well,
Sustained.
it
Yeah,
was,
no, you did ask. We already know that, Mr. Bruno.
it was a different witness. I have no other questions.
Yeah, I don't know what I mean, which witness did you ask that question of, Mr. Bruno? I'm trying to recall. Was it Mr. It was Mr. Settlage. So Mr. Shields and Mr. Settlage are here today. Mr. Shields is offered as the sponsoring witness to the exhibit, which was given in response to the bench request, and then the company provided as a courtesy, Mr. Settlage to answer any questions. The witness to whom you asked that question was Mr. Settlage. So yes, asked and answered.
Okay, I have no other questions.
Okay. Anything from any other party?
I have
Mr.
some
Baker?
questions.
Yes.
Yes,
Go
thank
ahead,
you.
Mr. Baker.
Thank you, Mr. Hearing Examiner. In the first bench request response, I would like to know if the adjusted table 7 and 8 cost for AMI is shown in a cell as rounding to $327 million. I'm wondering if that includes the 38.5 million cost of setting up the regulatory asset or if it does not include that cost.
The cost included in this cost benefit analysis is the cost from the original filing.
That's not my question. So the question is, in the cell in table 7 and 8, listed as the cost of AMI at approximately $327 million, does that or doesn't that not include the regulatory asset value that we now know is $38.5 million?
Objection. This is not specific to this bench request response. It's the same $327 million number that we've been talking about since phase 1.
What I'm trying to get at is the total cost of AMI.
Well, and I think I'm trying to think of what the answer is, and I think I know the answer, but I want to have confirmation that I understand. Mr. Shields, your response to Mr. Baker was, these are the costs of the initial application as proposed. It is my understanding, having reviewed the bench request responses and then spent some time looking at other documents in the record, that when the company filed the initial proposal, the plan was to create a regulatory asset for the undepreciated investments in legacy meters. So thus, it should be the case that those costs are captured here. Is that correct?
That is my question.
Well, I know it's your question, but I'm waiting for Mr. Shields to answer it.
Mr. Hearing Examiner, If I may, I think we're talking about the undepreciated the cost of the undepreciated legacy meters, and that is in fact the subject of the next witness and the next response to bench request. So
Okay. If he's not the best witness to answer that information, that's a perfectly acceptable answer too.
Yeah, I'll defer to the next witness, PNM witness.
Okay, so basically I would ask this question again. Is that?
Yeah, of the witness who, I mean, I think it's a fair question, and I think I suspect we're gonna get the answer is yes, it's included in the BCA, but we'll see.
Okay, I have one more question, and that is in the amount shown, actually in the second bench request response, has that been introduced, or can I ask a question on that or not yet?
No, we're not there yet on the second one.
Okay, so I'll come back to that.
Anything further for Mr. Shields?
No, thank you.
Mr. Elliott, you're raising your hand.
Yes, Mr. Hearing Examiner. I did have a question for Mr. Shields. On page 2 of the bench request response, in the first full paragraph, begins with reduced on-peak demand. The last sentence there says, the benefits of reduced on-peak demand could be realized sooner than 2030 if AMI deployment is accelerated and a default TOD is approved on a fast track basis. Was that a scenario that PNM modeled for the CBA?
Now, the CBA assumed that it would take the full 6 years to deploy AMI meters, and that we did not claim benefits until after the 6th year, given time for a time of day use to be developed and approved, and giving time for the AMI meters to be installed and all the ancillary work that needs to take place to have that functionality working.
So, no. Mr. Shields.
This was not modeled in the BTA.
Wait, I have to follow up on that, Mr. Elliott, before we move on. But I mean, so yesterday I attended the pre-EPE pre-hearing for, they have a grid mod application now too with us. And this relates to a pilot for time of day rates. And I don't know all the details yet. I just starting that case. So I guess the basic question I had for EPE then was like, well, how fast are we going to move forward on doing time of day rates, and when can the customers seem to receive these benefits? And Ms. Olson from Montgomery Andrews couldn't answer that question. We'll get there in the hearing. But I mean, I assume this answer, Mr. Shields, is predicated upon that the benefits could be materialized faster. It's just sort of simply the logic of, you know, the end result is customers will save money. That's what the BCA shows. If the commission is interested in achieving that outcome more rapidly, efforts can get there, and the same conclusions that flow from the 6-year plan should be materialized faster if we get through this all faster. Is that the basic thought you're articulating there?
It is. We wanted to take a conservative approach and not claim benefits earlier than the 6-year window. Obviously, the cost are on the front end, and the benefits start 6 years after. So in an effort not to overstate benefits, we made that assumption. Now, I would defer to Mike Settlage here on the timing of how fast that could be accelerated, but no doubt about it, some of this work can be done in parallel, and some of it can be expedited.
And I guess ultimately, my question is that, the commission does not want to stand in the way of benefits flowing to customers. I mean, of course, it's our job to ensure that there will in fact be benefits. That is a question. That's kind of the whole question of this entire proceeding. But it's my understanding from the company that to the extent to which the commission has a prerogative about how fast it wishes to work, PNM is going to work with the commission to achieve that objective. Mr. Shields, you might not be the witness to answer that question. I might just be more stating something that I understand to be the case more than anything.
Seems reasonable.
Okay, go ahead, Mr. Elliott. Keep going.
Well, just to follow up on that thought, Mr. Hearing Examiner, am I correct? So if you adjusted the time frame for implementation and you moved up deployment, that presumably would front load certain costs, right? And this might be a question more for PNM's other witness, but am I correct in general that if you accelerated it, you'd also be front loading certain costs more?
Potentially.
Right. And so if the concern of the commission is how fast those costs come into rates, then accelerating would come at a cost. Is that fair to say? Additional costs, let me say.
They would be joined with additional benefits.
But right, additional benefits with additional, nothing's free, right?
Yeah, if you're going to accelerate the cost, the benefits would be joined with them at the same time, if it's accelerated.
So, and you know, but Mr. Elliott, I mean, I understand we're engaged in a dialogue here more than so much questioning of the witness, which is actually productive, because as Mr. Morgan was finishing his testimony, my thought was, you know, the point about increasing costs is if we wait, more costs. If you act, costs. I mean, it just seems like there's I don't know what the answer is to that question.
Briefing. Where we will explore and delve into the depths of our thoughts.
Yeah, right.
For you to read and absorb.
But you know, that was the thought I had with Mr. Morgan. I mean, in one sense, his testimony stands for the proposition: lost opportunity. Commission, you waited, costs increased, and now look where we are. And in some sense, that's as problematic as I think your point's well taken, which is to say, hey, you know, if you accelerate, there might be additional costs, but if we wait, there's the same problem, according to Mr. Morgan, anyway.
I have no further questions. Thank you.
Anyone else with Mr. Shields?
Mr. Hearing Examiner, I just wanted to follow up on one thing, and you know, I didn't hear the answer clearly. I recall, was it Mr. Baker asking about whether the legacy meter retirement costs were factored into the cost benefit analysis?
And I believe the answer was that Mr. Virchul indicated that the appropriate witness to ask would be the next witness, and that Mr. Shields does not have the best insight into the answer to that question. Is that right, Mr. Virchul?
It is.
So the next witness, Commissioner Elson.
That's fine. I mean, I know Mr. Shields conducted the cost benefit analysis, but if the next witness is more appropriate, that's fine.
All right, if there's nothing further, Mr. Shields and Mr. Settlage, I appreciate you very much making yourselves available again today, particularly Mr. Settlage. Thank you, sir. We didn't have much discussion with you, but you know, it is appreciated you come back and make the effort. The commission appreciates it. Thank you.
Thank you.
Thank you.
Mr. Shields, thank you too, sir, for coming back, and appreciate your time.
Thank you.
You're both excused. Thank you.
Hearing examiner PNM calls Kyle Sanders. I think he'll just have to get into the witness room.
And we will have to swear Mr. Sanders because he was not
That's correct.
He has not been sworn yet.
He's making his way over there now.
That's fine.
He has been, sorry, apologies.
It's okay.
Mr. Lee, can Mr. Sanders please be sworn?
Mr. Sanders, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter and opinion should be the truth, the whole truth, and nothing but the.
Yes, sir, I do.
Thank you.
Can you state your name and title for the record, please?
My name is Kyle Sanders. My title is Executive Director of Financial Planning, Corporate Budget, and Cost of Service with PNM Resources.
Thank you, Mr. Sanders. Do you have in front of you what's been marked PNM Supplemental Hearing Exhibit number 30, which is the Supplemental Hearing Bench Request number 2, or the response to the bench request number 2?
Yes, ma'am, I do.
Thank you. And was that prepared by you or under your direction?
Yes, it was.
Is that response to Supplemental Hearing Bench Request 2 true and accurate to the best of your knowledge?
Yes, ma'am.
And just for clarity, Mr. Welliger, before we go on, I just want to do one thing.
Sure.
So that the actual bench request, so on the paper that I'm looking at, which is entitled Public Service Company of New Mexico's Response to Second Supplemental Hearing Bench Request made on April 24, 2024. Supplemental Hearing Bench Request 2 is identified as the hearing examiner requested that PNM provide the undepreciated value of PNM's meters. And just for clarity of the record, I think the question really is the undepreciated value of PNM's legacy meters that will be replaced by AMI. That's the question you're answering there.
Yes, sir.
Just wanted to make sure.
Thank you, Hearing Examiner. If I asked you this same question today with the clarification, this is regarding PNM's legacy meters, would your answers be the same?
Yes.
We move for admission for PNM Supplemental Hearing Exhibit number 30.
Any objections? PNM Supplemental Hearing Exhibit 30 is admitted.
Mr. Sanders is available for commission questions or cross-examination.
Commissioner Ellison, do you want to start us off where we left with PNM indicating that this would be the witness to which you should ask your question?
I'm happy to do that. I could also go last. I'm indifferent on that.
Well, I'll just ask it then, and we'll just see where the dialogue leads. So, Mr. Sanders, the basic question was whether or not the benefit cost analysis incorporates the costs associated with the legacy undepreciated meters and the regulatory asset the company plans to create for them.
I was just listening. And I will clarify, I was not greatly involved in the cost benefit analysis. I do not believe that the cost of the legacy meters were included. The company's position was to request the regulatory asset to be recovered in base rates, where those existing meters currently are recovered. And the cost benefit analysis was very intended to be focused on incremental costs related to the grid mod application, whereas these are existing costs that customers are paying today. And so I do not believe that those costs were included as part of the cost benefit analysis.
Okay. And Mr. Sanders, perhaps just explain to me I'm familiar with your work at the company and the complexity of understanding costs. So I guess my question is, should the commission infer from that there is some aspect of the benefit cost analysis that fails to capture costs? And if your answer is no, but just explain, please.
So, I mean, I guess again, I was not totally involved. I'm not exactly sure what all aspects and everything were completely looked at, but I would say no from that, as you know, the grid modification rider, as we've proposed and things, was really focused on incremental costs that are not currently existing within customer rates and the benefit of which those costs would provide to customers.
And elaborate on why are the difference between the incremental costs versus the base rate costs, and how that distinction works in your mind.
Sure. I mean, base rate costs, I mean, for lack of better terms, would be kind of our business as usual type costs, our regular infrastructure investments, costs to, serve our customers and those type of elements. Whereas the grid modification application are truly things to technologically advance our system, that falls into that bucket, that represent incremental costs that otherwise the company would not be investing in. Whereas the meters are an existing cost that customers are paying today, and would continue to be collected through base rates under the proposal of the company.
Okay.
So
Commissioner Ellison, if you look at like you're eager to jump in here.
So I guess what I'm hearing here is that, so in the cost benefit analysis, the benefit of not needing to replace the legacy meters as they, age and need replacement was included. However, the cost of retiring the legacy meters in order to install the AMI was not included.
Yes, again, was not super involved in it. But the cost to, the avoided cost of not having to replace meters, I would say, is actually a true incremental cost that would be incurred if, say, AMI, and the grid mod proposal was not approved by the commission. We would have a very discrete incremental cost. We have had a variance for replacing meters for, I don't know, a few years now, I believe, of which, there are very distinct costs that we would need to almost immediately replace full batches of meters. And those capital costs would be expended to meet that, as well as future collections. And so to me, that is comparative of the replacement with new AMI meters versus I would still have to replace meters with, the existing technology of meters today. And so those are two comparable bases. Either way, I would still collect the net book value currently on my books and records, either through, existing depreciation or future depreciation rates, as we get there.
Okay, yes, but if you install the AMI meters, then from the customer's viewpoint, you're collecting depreciation and potentially a carrying cost, a return on both sets of meters.
Yes, from a customer revenue requirement perspective, that would be collected both.
And so if the decision is to implement the AMI rollout or not, clearly, if the decision is to implement, then retiring the legacy meters early is a cost that consumers would not bear if AMI were not rolled out. Would you agree with that?
So no, I don't think I agree 100%. I understand the concept. I would say that the consumers would still bear the cost of the existing meters. The cost that they would not bear would be the new cost of AMI meters if those were not to roll out under the way you said it.
I understand your point there. Is it typical to earn a profit on equipment that's no longer serving customers?
That issue comes up quite often in these proceedings. I would say different jurisdictions, different treatments. Obviously, here within New Mexico, at least within PNM, I would say it's not 100%. We're not, we have some here at PNM, such as the retirement of San Juan units 2 and 3, that we do earn a full return on and of that, retired plant. We also very recently in the rate case, the 22-270, there was rulings to receive debt-only returns on portions of retired plant, as well as then, some was just a return of the retired plant specific to Palo Verde investments for expiring leases. And so I don't know that the treatment is a yes or no question. I think there is examples for each, and it is very much so a asset by asset, case by case evaluation that the commission makes.
Right. I mean, would it be fair to say that, when we're talking about, assets such as San Juan, we're getting into the legislative decisions in statute involving the Energy Transition Act and the potential issuing of bonds that, really are a separate case.
So actually, no, that would be very specific for San Juan's units 1 and 4, of which retired at the beginning of 2018, 2022, 2020. Those just retired. Those are what are subject to the ETA. San Juan's units 2 and 3 are the ones that are still recovered through base rates and the retirement of that. Those were subject to a stipulation in case 13390 UT,
Okay.
I believe,
Okay.
under the BART case.
Okay.
In our
those
ETA.
also got a 50% write down, if I'm not mistaken, in the undepreciated asset. So I don't want to get too much into the weeds of specific cases here, but from the customer standpoint, does it seem reasonable for the customer to pay carrying costs on 2 sets of meters, one that's been removed and the other that's been put in service?
I mean, from my perspective, yes. Those are costs that our company did incur, very prudently incurred, to provide our service to our customers. And if it is determined that there is a benefit to customers to move towards AMI and roll out the AMI, then I absolutely believe that the carrying charge is a valid cost for achieving that benefit to customers.
And I would imagine you could make the argument to suggest that because the commission previously, I mean, it's sort of like if AMI is if that's going to happen at some point, if that's what the grid mod statute's about, and to the extent to which you need to know where the feeders are, and that requires investments for distributed energy resource improvements and then load shifting, because the customer needs to know what their usage. Right. Like, so I guess my point to you is, I don't mean to be babbling here, but the commission previously denied an AMI application. We know that much.
That is my
Yeah,
understanding.
so to the extent to which additional investments have been made since 2015 on analog meters or meters that are not advanced and have capabilities, I mean, the company was forced to make those investments because they couldn't do anything else.
I mean, yes, we serve, we make the investments necessary to serve our customers, and replacing and investing in meters is one of those investments.
Right.
The forced is where I kind of like, I mean.
Well, you need a meter.
Yes.
You have to have a meter, I assume. Yeah, in that sense, I mean, I was listening to your conversation with Commissioner Ellison. I mean, and the San Juan and the big generating units, those examples are potentially, different because unlike, I mean, the writing about them and all the controversy, I don't feel like getting back involved in it anyway. But here, you needed to have the meters. You were utilizing meters. You were told you couldn't have AMI investments. And so now you have all these meters that are sort of old technology. So what do you do with them?
Well, I mean, there's no question that, in my personal opinion, that the legacy meter investment, was prudently incurred. I don't think there's going to be any argument on that point. But, clearly if, this is a voluntary program, AMI is not required. And if the old meters are taken out, did we lose the commissioner?
He appears frozen on my screen for what it's worth.
Yeah, it's gone for me too.
So does hearing examiner Ryan.
Those are the most fortunate freeze frames I've seen.
I'm going off the record.
That's probably good.
It appears I'm the host now. We've lost Mr. Borman as well. It looks like we've lost the commission.
We can take this opportunity to admire your bow tie.
Thank you, sir.
I contemplated wearing a bow tie today. I like the bow tie. It's good style.
I'm getting a phone call from the commission.
Watch what protein shakes do to your body.
We have lost the commission, and that was Anna. I'm sorry, it looks like they're coming back. Commissioner, can you hear us?
I can.
We don't have the judge yet.
You can tell we're in the Bochum building.
Yes, sir. We are off the record.
Okay.
Here we go. We don't have Mr. Borman yet.
Yeah, did Commissioner Ellison, are you in the building?
I am.
Did you go out as well?
Yes.
Yeah, we lost everything here. I saw the IT guys out in the hallway, scrambling to fix stuff. It looks like it just was a inexplicable technical glitch, which invariably happens. Let's see. Is anyone in the waiting room? No. So we have our witness, we have PNM, we have parties.
We
All right,
don't have Mr. Borman.
He will jump back in when he needs to. I think we can probably carry on for the moment. Are you ready to go back on the record, Mr. Lee?
Yes, sir.
So at the we just had a technical problem. Internet crashed here at the Bochum building. The commission is housed and where I am and where Commissioner Ellison is. So nothing we can do about that. But Commissioner Ellison, you were in the middle of saying something, which the words that I recall were, there's no question that the investments in the legacy meters were prudent. And then I assume there was a but coming after that word.
Yes. Okay. Thank you. If you view the AMI deployment as an optional a choice, as I do, then the cost of retiring the legacy meters early is clearly a cost. And it seems that there are a range of reasonable treatments regarding the amortization period and profit on those meters. So the mere fact that they were prudently incurred, in your view, Mr. Sanders, does that necessarily mean that they should earn a profit even if they are not serving customers?
Sure. So, I'm gonna try to make a few clarifications on it. While AMI is, a discretionary program, I do actually think the company was ordered to file a plan with it. And so that is what we have proposed here. And so, by the commission's, ordering have a plan, I do think under that yes, the prudently incurred cost of the meters should receive a full return on and of. I would say that generally, even if it hadn't, in order to provide benefits to customers of something of this order, the utility and investors and the investment shouldn't necessarily be penalized by foregoing the return on the cost of that investment. And I would say, there are true costs tied to those. The company did take out debt to fund these investments. And, there is equity funded into the business to fund these investments. That, yes, I do believe, since they were prudently incurred, the company should collect. I can't think of the word I actually want to say. I apologize. But yes, we should have the ability to collect those true costs.
Okay, I understand your argument there. in your view, if the carrying cost were not allowed, would that change PNM's desire to implement this program?
I mean, one, I'm not sure that I can speak to the company's desire to do that. So I don't know that I can confirm or deny. I mean, it would definitely be, I would say, a chilling factor for looking for opportunities to provide benefits of these costs if they required a retirement, an early retirement to investments, if you had to forego collection of your costs.
Okay, I would say collection of profits, but I understand your point. On the time of use issue, we discussed with Mr. Shields that the cost benefit analysis assumes that the benefits of the time of use opt-out program would not start until all of the new meters are installed, which was assumed to be in the 2030 time period. Should we conclude from that PNM intends to wait until all AMI meters are installed before rolling out an opt-out time of use program?
I apologize, sir. That's not in my testimony, and then I'm not exactly sure the plan on opt-outs.
Okay.
Yeah, I think maybe Settlage would have been, but I don't know.
Okay, that's fine. Okay, I think that's all I have. Thank you, Mr. Sanders.
Thank you, Commissioner.
I see Mr. Albright raising his hand. Mr. Albright, I assume you have questions you'd like to ask Mr. Sanders.
I do, just very briefly.
And just to recall, just to reiterate that, the scope of the questioning should be within the inquiry that generated the supplemental testimony and the questions that you just heard asked of the witness.
Yes, sir. And it relates to number 30 with regard to exhibit number 30 that was introduced. That's the second bench request here.
Yep.
So and this may be a little bit duplicative of what Commissioner Ellison asked, but on page 2, I'm just looking to get some clarity here. Lines aren't numbered there, but where it has just down from the top, it says the continued amortization of legacy meter costs in a regulatory asset means the PNM will be seeking recovery in a future rate case of an amount that reflects the remaining net book value of the meters. Do you see that language, Mr. Sanders?
Yes, sir.
Okay. And when you say the remaining net book value, you're talking of the legacy meters there, correct?
Correct.
Okay. So that essentially amounts to, and 2 questions. One, that's essentially then stranded costs for those legacy meters that would be part of a rate case, correct?
So, yes. Can I clarify kind of what the language is really speaking to? It's from my direct testimony in this case. But under PNM's proposal, we proposed that as AMI was rolled out and legacy meters were retired, they would be recorded to a regulatory asset. Once in that regulatory asset, they would still continue to depreciate at the currently approved depreciation from the commission until such time, and continued through, but until such time they could be reflected in rates. Generally, that's not the case when you have a undepreciated plant investment that is placed into a regulatory asset. It actually stays static at the value at which it's retired to until such time that it can be placed into rates for recovery. But given the unique nature of this and the timing of the recovery of replacement meters through the rider, we felt it was appropriate to reflect the declining balance of that regulatory asset even prior to when it could be reflected in customer rates.
Okay, and that would be the second question related to that same language that's in there. That would be for all classes, correct? Not just those that are under the pilot program or anything. This would be for all legacy meters for all classes, correct?
I guess I'm not sure what it is related to the AMI meter replacement rollout and the retirement of legacy meters as proposed in this case.
Okay. And then going to the last part of the last sentence of that paragraph on page 2, you have, and the recovery of the cost of the replacement meters, and I assume you're talking replacement AMI meters via a mechanism separate from base rates. So there you're talking, would that be via a tariff rider?
Yes, that is the AMI that is proposed in this case, and we have requested it as a rider mechanism within our proposal in this case.
Okay, so that relates when you say of the replacement meters, you're talking replacement AMI meters.
Yes.
In that case, okay. If people have opt out and still have legacy meters, how would they be handled?
I mean, to the extent somebody opts out prior to replacing its meter, that meter would never be retired and never be placed into the regulatory asset.
Okay, that's all the questions I have. Thank you very much, Mr. Sanders. Appreciate it.
Mr. Bruno, and then Mr. Baker.
It's I'm just curious, there's no mention in this exhibit 30 how the value is calculated. So if the meters are sold used or if they're recycled, how is the proceeds of that treated? If there was, if there is a recycled value to the meters.
Sure. So the number reported here truly just reflects our undepreciated balance on our books today for those meters. Being that they have not been retired, there is, we don't have the recycled value or any of that. Any positive salvage value for a meter would go against the regulatory asset. I'm not positive on our depreciation rates. I will say a lot of times there's what's called a net negative salvage on depreciation, of which there is actually a cost associated with disposal of existing assets. We collect that under our current depreciation rates. It's built into those functions. So we would assume that just the net book value would be what is ultimately retired to the regulatory asset.
Another question is just if people are opting out of AMI and would like to have an electromechanical meter, would it be possible to set aside meters for that purpose?
I do not know what our possibilities or costs of different technologies and different meters would be.
No more questions.
Mr. Baker.
Thank you. I wanted to dig just a little deeper into what is shown in the cost. In Exhibit 30, the total appears to be about 38.5 million, correct?
That is correct.
And does that include the legal costs and other kind of setup and ability to collect, or is it just the value of the meters? Is 38?
It is just the undepreciated value of our legacy meters.
Okay, so the cost of setting up the regulatory asset would be something greater than $38.5 million.
Can you clarify what you mean by the cost of setting up the regulatory asset?
The legal fees and the rider and the hearing and the all the rest of to make that actually collectible. There's other costs, right?
I think I understand the cost you're talking about. They are not specific to the legacy meters at all, which is what,
Just setting up a regulatory asset.
Right. And so those costs are not specific to this at all. They were actually, and those cost estimates are included within our cost estimates of all of the capital investments that are made within this case under general accounting. The cost to complete that and get those projects through and all of that would be considered capital and are included within our cost estimates. So those costs are absolutely included in the overall cost of the program. But they have nothing to do with the regulatory asset in setting it up here.
Okay. So the cost of setting up the regulatory asset for the recovery of legacy meters would be at least 38.5, but may also include legal fees and whatever.
So no, I think we may be talking past each other.
Okay.
There is no cost to set up the regulatory asset. It is an accounting journal entry to move it out of our net book value and our plant and service and into a regulatory asset upon retirement of the meters. Any cost to facilitate AMI and those type of things would be included within the costs of our programs that have been proposed within this case. So very distinctly different. There is no cost.
Okay. So let me bring it back. Some of Commissioner Ellison's line of questioning back for my benefit as a ratepayer. From my perspective, I got a little bit lost in some of the other cases, and I wanted to bring it back so I'm clear on whether or not creating a regulatory asset for the recovery of the undepreciated value is or is not included in the $327 million in the adjusted table used for the cost of AMI.
Objection. I think this has been asked and answered.
For the benefit of Mr. Baker, the witness can respond. Go ahead, Mr. Sanders.
Sure. I'm not sure what table or the number you quoted. As I've said, I was not greatly involved in the calculations of the cost benefit. My understanding, though, is the amortization and return on the regulatory assets for undepreciated investment was not included in the cost benefit, as it is not distinctly an incremental cost of the program.
Okay. So the reason I was asking that is that as a ratepayer, it is indeed, it appears to me that that is a part of a cost of the AMI program, since it's a voluntary program. And by incurring, if we move ahead with AMI and we incur a cost that we would not otherwise have, it seems to me, as a ratepayer being asked to provide revenue, that the cost of AMI goes up while the benefit does not change, which should affect the cost benefit ratio of the AMI program. That's why I was asking. So I don't understand. So let me ask a question. I guess I'll just have to rely on how you answered Commissioner Ellison, because I don't understand, as a ratepayer, I don't understand how you can exclude that cost when it's associated with the implementation of AMI.
Oh, yeah, go ahead, Ms. Tilwelliger.
I'm not sure Mr. Baker was ever getting to a question.
Yeah, sustained.
Okay, then I'm done. I can't think of a way to clarify it.
Anything further from anyone else for Mr. Sanders?
I mean, if I could ask a little redirect, if everybody else.
Sure.
Um,
Please go ahead.
I think Mr. Elliott has his hand up though.
Okay.
Thank you. Mr. Sanders, I just wanted, I can't remember if it was the hearing examiner or one of the other interveners, but to your knowledge, there's nothing that actually prevents PNM from replacing a meter that's failed with a advanced meter. Is there?
I don't know. Not that I'm aware of, but I don't know.
Well, let's assuming there isn't. What would be the rate? What's the difference in the rate making treatment? So as proposed here, right? So if one is just one is broken and it needs to be replaced on a customer's home, how does that get handled in rates?
Objection.
Yeah, go ahead, Mr. Welliger.
Assumes facts and evidence. I mean, PNM has not presented a case where legacy meters are replaced one-off with AMI meters.
Well, I can modify my question if that would be.
Sure. Go ahead.
Let's say it's a digital meter. I think we already heard testimony today that analog meters are replaced with digital meters on occasion. So how would that work as opposed to a rider?
Sure. And so I will try not to get too detailed into accounting, but I'm going to have to a little for you to get to the rate making. I think what you're asking is just if we replace existing meters as it's failed or something of that nature, how would that work, right? And so if I have an existing net book value on a meter that fails and I need to replace it, that meter is retired into the accumulated depreciation balance or accumulated reserve balance. And the new meter is booked into what is called gross plant. The net of those two become your net book value. And so then if you had a big enough value of that, you could actually have an accumulated depreciation that is a positive number for it, of which then those would go into your next retirement curve in your depreciation study. That would say meters are retiring earlier than they are being fully depreciated, increasing that to accelerate the cost. And that depreciation would look at what it takes to recover the net book value, not just the gross plant. So as that retired meter would then be recovered through your depreciation rates, and the full net book value would be placed into base rates, receiving a return on and of it.
And does that happen? So presumably that's happening now.
Yes, that happens with all plant we retire on a regular basis.
So you batch them, or it's just on a rolling basis as customer accounts indicate a meter has been replaced and retired?
Objection.
Yeah, hold on, wait. Let's hear the objection.
This is getting pretty far afield of the bench request, I think, and of the commission questions.
Mr. Elliott?
I think it's a reasonable question. It's my last. If what it specifically goes to is the alternatives here. And to the extent that that's the purpose of the CBA, understanding the difference between how individual meters can be replaced or are replaced and how PNM handles it in a base scenario relative to what it's proposing for extraordinary rate treatment, it's relevant.
Yeah, okay. I'll overrule the objection. Go ahead, and if you need to, do you need him to re-ask the question, Mr. Sanders?
It would be helpful.
I was asking, PNM handles this now in base rates, right? I mean, in presumably a certain number of customers have their meters fail a month or within a year, and then you batch them. How do you handle it?
So I'm not exactly sure what you mean by batch them. I would point out by first saying I believe we have a variance for the commission rule on like how we replace them. I'm not really sure all on the rule, just from I know we have a variance for that. So currently I believe we are only, investing in meters for new meters, as well as then if a specific meter fails for a customer. And so then those are replaced. I do think under commission rules that we have a variance for, if there's failed meters or you have to do so much testing, which then you have larger replacements at a given time, which we've had a variance for. And so currently it really is, I think, more of one-off. But again, that's my general understanding. I am not the meter expert. I am not, the engineering people or any of that. I don't really know how all that works.
So my last question is just, it's really about me. Everything is ultimately, if my meter fails, right, would my bill reflect the added depreciation cost of paying for my retired meter? Would that just for my bill, or
So it's not on a meter by meter basis that we analyze depreciation rates. Depreciation is done on what's called group class. And so we would look at the total of that FERC plant accounting structure and look at the curves and analysis of all of that group class. It is not specific to any one class, as well as, depreciation rates do require approval. And so they don't change instantaneously.
Maybe it wasn't a poorly articulated question. If my meter fails and you replace it with a more sophisticated meter, will my bill change to reflect the added cost?
I guess I don't understand the question. I feel like that's what I just answered, in that your rates won't change absent, some form of commission approval to adjust rates.
And my bill won't change effectively.
Absent a commission approval to change rates, I mean, usage and things of that nature can change a bill, obviously, but the rates are set and established by our commission.
Okay. No, it's just helpful for me to understand, like if my neighbor's meter fails or if my meter fails, we're going to be treated as a class of customers subsidizing the replacement of everybody else's meters. It's going to be spread out across. It's not that you're tracking my account.
So can I clarify one thing? Because I heard what you said there. You said a class of customer, and that's not what I mean when I say in a group allocate, like depreciation rates is for meters, specifically FERC account 370, which has all customer classes within it. How those are allocated to other classes and between classes, I'm not that expert at all, but a depreciation rate is calculated on the entire group function or FERC class accounting, which is FERC account 370 on meters, which includes residential, industrial, all classes. And so I want to be a little careful with the class qualification you're using.
But we are getting pretty far afield. But I mean, the basic concept is that ultimately becomes integrated into what the cost of service is, right? The depreciation rates. But here we have the added complexity that the legislature specifically authorized a grid mod rider. So it would depend on how you're collecting these costs, which you don't need to address, Mr. Sanders. I just throws another added layer of complexity to it all.
Thank you for indulging me. I appreciate it.
No problem. Anyone else? Mr. Sanders, thank you for appearing today. Sorry, Mr. Welliger, I apologize. Yes, you want to do some redirect. I'm sorry.
Yeah, I didn't think you were including me in that group. Sorry. Just real quick, a couple of questions. Mr. Sanders, you testified in this exhibit, PNM Supplemental Hearing Exhibit number 30, as to the undepreciated value of PNM's meters as of September 2023, and you've had some questions on that value. Is that right?
That is correct.
Do you know if PNM, if the commission orders PNM to delay implementation of AMI, or if it denies the AMI program, is that cost of legacy meters that has to be depreciated, is that likely to go up in the future or down? Or what would you expect? How do you think the remaining undepreciated value of PNM's meters will change over time if the commission does not permit or delays AMI now?
I think it'd likely go up. Just we do invest in new meters for new services, as I discussed. The failed meters, all of those do have cost to them, and so it would likely increase our value of undepreciated investment. Those would be offset by depreciation and continued depreciation of the existing. But I think historically, just kind of thinking back, that value has increased over time.
That's all my questions. Thank you.
Okay, thank you, Mr. Sanders, for joining us today, sir.
Thank you. Appreciate
your participation. Yep. And I believe that brings PNM's case to a close. Is that correct, Mr. Welliger?
We have one more bench request, Mr. Hawkins.
Okay.
Bench request number 3. I think hopefully we could fit it in before lunch.
Yes, absolutely. Let's do that.
Mr. Verheul is doing that. So.
And it'll just be a minute for our witnesses to swap out again.
Sure.
There we go. All right.
All right.
Sorry. Go ahead.
No, please, you go ahead, Mr. Verheul.
PNM calls John Hawkins.
Mr. Hawkins, you have already been sworn in on this proceeding when you testified previously. Do you recall that, sir?
Yes, sir.
And you understand you're still under oath at this time?
Yes, sir.
Mr. Verheul, go ahead with the submission of the bench request answer.
Thank you. Good morning, Mr. Hawkins. Do you have before you what has been labeled PNM Supplemental Hearing Exhibit 31? This is the PNM's responses to Supplemental Hearing Bench Request number 3.
Yes, I do.
And just to be clear, this is in response to the request regarding PNM past and expected upcoming applications for federal funding for grid modernization related projects. Is that right?
Yes, it is.
Okay. Was this prepared by you or under your supervision?
Yes, it was.
Is it a true and accurate account to the best of your knowledge?
Yes, it is.
Are there any additions or corrections to it?
No, there are not.
If I asked you the same questions today, would the answers be the same?
Yes, they would.
Mr. Hearing Examiner, I move to admit PNM Supplemental Hearing Exhibit 31.
Any objections? None heard, so PNM Supplemental Hearing Exhibit 31 is admitted.
I tender the witness for questioning and cross-examination.
So this was partly a a request prompted by the Attorney General's inquiry. So I wonder if they have any cross for Mr. Hawkins.
I don't have any cross, and I appreciate the company preparing this exhibit.
Yeah, I'd have to take the time to digest it and look at it before I could ask anything meaningful myself, Mr. Hawkins. Thank you. And it just gives us context, I think, moving forward as to what the company's doing to offset costs wherever it can. Anything from anyone else? Mr. Hawkins, thank you for reappearing and coming back to help us with this information. It's greatly appreciated, sir.
No problem. Thank you very much.
Thank you. Okay, now I believe that's the end of PNM's case. Correct, Mr. Verheul?
It is, sir. Thank you.
All right, so it is now 11:30. I'm going to suggest we do the lunch break and just have a slightly early lunch and then come back at 12:30 and conclude, and then we should be able to wrap up. I guess I said I did math earlier. I think it's something like 3 hours if everybody uses all the time that they've actually outlined. And I'm not sure. I found the PNM's fairly efficient with their cross examinations and oftentimes don't use all the time. Not that I'm assuming that'll happen, but I think we've got plenty of time to finish everything. So let's break for lunch and see everybody back here at 12:30. We're not on the record just yet, but Mr. DeSayan, is Mr. Kenny?
Yes, he should be joining momentarily.
I'll keep my eye on the waiting room.
Thank you.
And then Mr. Elliott, it's Miss Lane, because it doesn't look like Mr. Kenny has a lot of, by my record here, I think we have 5 minutes with Mr. Kenny from one party. So is she ready to go?
Yes, in fact, I was just gonna respond to an email. Can she sign in now and she'll be on deck, or do you want her to sign in when?
She can sign in and just sit in the waiting room, and then that's just one less panel for us all to see on the screen, you know?
Okay.
But I will remember that she's there, and we'll admit her as soon as we're done with Mr. Kenny.
Okay.
And then we got, again, we're not on the record just yet. I'm just going through the order here for planning purposes. So we got Mr. Kenny, Miss Lane, Miss Reno. Is Mr. Albright, is she ready to go?
You're on mute, Mr. Albright.
Had to get the arrow to the mute button there. Yeah, she is ready to go.
Great.
Mr. Hearing Examiner.
And then Mr. Baker, and finally Mr. Tupler. And I don't think there'll be any problem fitting everybody in. So, all right.
I'm just wondering, as an intervener, how do I introduce myself or present myself?
So what generally the hearing examiner will assist the pro se interveners with admitting whatever testimony they seek to admit.
Okay, great. Thank you.
Okay, back on the record. It's 12:30. We've returned from our lunch break here. Is Mr. Bruno still with us? Yes, I see his panel. I don't see his. I'll just say for the record, I did communicate with the records department, and the reason that oh, there you are, Mr. Bruno. Yeah, we communicate with the records department. The email they showed me is that the comment was sent not to the correct records address. The correct email address for the records department is prc.records@prc.nm.gov.
I did find that out also during the break. Thank you.
Yeah, I just want to say it on the record since we had discussion on the record as well earlier. Okay. Mr. DeSayan, you may call your witness, sir.
Thank you, Mr. Hearing Examiner. Coalition for Clean Affordable Energy and Western Resource Advocates call Mr. Michael Kenny.
Mr. Lee, if you could swear in the witness.
Mr. Kenny, if you would please raise your right hand. You solemnly swear the testimony you're about to give in the matter and opinion should be the truth, the whole truth, and nothing but the truth.
I do.
Could you state your name, please, and spell it for the record?
My name is Michael Kenny. It's MichaelKenney.
And could you state your business address?
Yes. So my business address is with Western Resource Advocates, and that is 2260 Baseline Road, Suite 200. That's in Boulder, Colorado, zip code 80302.
Okay, and where are you employed, Mr. Kenny?
With Western Resource Advocates, which is different than when this testimony was filed.
Okay. And on whose behalf are you testifying today?
On behalf of both the Coalition for Clean Affordable Energy and Western Resource Advocates.
Okay. Now I'd like to refer you to a document that has been marked as CCAE-WRA Supplemental Hearing Exhibit 1. Can you identify it, please?
Yes, that should be my responses to the bench requests filed on January 30th of this year.
Okay, and is that designated as second supplemental testimony of Michael Kenny?
That's correct.
Okay, and did you prepare it?
Yes,
And is it true and accurate to the best of your knowledge?
yes,
And are there any changes you would like to make to it?
no,
Um, uh, would you would you like to correct the statement of your employer?
yes. Other than amending my current employment and that business address, that would be the only change.
Okay, thank you. And with that correction, do you adopt it as your testimony today?
I do.
Okay, then I'd like to refer you to a document that's been marked as CCAE-WRA Supplemental Hearing Exhibit 2, and that's the corrected version. Can you identify?
Yes, that would be my testimony in response to the benefit cost assessment filed by PNM.
Okay, and is that designated as a third supplemental testimony of Michael Kenny?
Yes,
Okay, and did you prepare it?
yes, I did.
And is it true and accurate to the best of your knowledge?
Yes, it is, though, with the same caveat of the employer and business address.
Okay, and that kind of leads into my next question, which is, are there any changes that you would make to it other than that?
No changes other than that one.
Okay, and with that correction, do you adopt it as your testimony today?
I do.
Thank you, Mr. Hearing Examiner. I'd like to move for the admission of CCAE WRA Supplemental Hearing Exhibits 1 and 2.
Any objections? I hear none. CCA, WRA, supplemental exhibits 1 and 2 are admitted.
Thank you. And Mr. Kenny is available for questioning. Thank you.
And I believe Mr. Albright, you have requested 5 minutes with Mr. Kenny.
Yes, that's correct, Mr. Hearing Examiner.
Go ahead.
Thank you. Good afternoon, Mr. Kenny.
Afternoon.
My name's Jeff Albright, and I am counsel on behalf of Bernalillo County. Just have a couple of questions for you. So I would like you to turn to your third supplemental testimony. My questions revolve around that.
Okay.
Do you have that in front of you there?
I do.
Okay, and specifically, I'd like you to turn to page 10, please.
Okay.
All right, and I want to make a reference to the question and answer between lines 11 and 16.
Okay.
Are you there? Okay. So you make the recommendation there, the PNM on line 14, PNM should report that data to the commission and to the public, and that you recommend at line 15, additionally, I recommend PNM include a quantification of these benefits in its future grid modification applications. Did I read that correctly?
That's correct, yes.
So what do you have or mean with regard to for that information as to periodicity, or what would be a reasonable time frame that you would have with regard to reporting that data?
One example would be through the annual true-up period that PNM has suggested in this case. That could be a place for them to report that. Depending on the specific technology, say with whether it's time of use rates or the DERMS. There could be other applications that they put that information into, say their energy efficiency triennial plans. They could file it, within a rate case. There's many avenues. I don't have a specific requirement. It just should be available.
Okay, and that's what I was seeking, whether or not you did or did not have a specific request or recommendation to make. But it's correct to state that your request is a variable one then. And would that be left to PNM's discretion or the commission's discretion? You have a sense for that?
I imagine I would leave that to the commission's discretion on how they would like that information reported if they find it valuable.
Okay, and referring to the a little bit earlier in that paragraph there at the very beginning, line 12, you recommend that PNM be required to gather data on the benefits of reduced emissions of greenhouse gases and other pollutants. Do you see that?
Yes.
And what kind of data would you be looking for?
So that would be the, say, emissions from PNM's operations. So it could be their electricity generation. It could be from emissions from buildings or from electric vehicle charging. And then how is that emissions offset by the different technologies, we're approving here or seeking to approve in this case. And so that would be, what is the amount of emissions? And then is there $1 per ton associated with that emission that you can quantify as a benefit when, say, with a DERMS or with time of use rates, time of day rates, you are reducing what would have otherwise been emitted.
And would that be on the same periodicity as the other, when you refer to report that data to the commission and the public along the what you earlier mentioned in during our discussion here?
Yes, that would be the same information.
Okay, in the same time frame as those other reports?
Ideally, yes.
Is that true? Ideally?
Yes.
All right, that's all the questions I have, Mr. Hearing Examiner. Thank you very much, Mr. Kenny. Appreciate your answers and your time.
Thank you.
Just a few questions, Mr. Kenny. I don't see any other interveners requested time with you, so I just while I was speaking with PNM's witnesses this go around, it occurred to me, that there was this question about the cost that homeowners or ratepayers are going to have to absorb to install rooftop solar on their houses. And to the extent to which we're going to have a distributed energy resource system, that's going to be a cost someone's going to have to bear. And I asked the PNM witnesses, well, is that just kind of a hole in the program or the plan here? And Mr. Warner's answer was that no, it's not. And I think that's because, and I have some recent news articles talking about the varying benefits that are available to residential customers to install solar rooftop. I just saw some, and there seems to be a relatively robust amount of funding out there to assist people with the costs of installing rooftop solar. Is that the case? And my broader question is there something missing here that PNM should have done about, helping people with the cost of the solar installation on their houses?
I would say to that question, within the scope of the benefit cost assessment, I don't believe they needed to capture the cost of solar, customer-sided solar. Whether or not PNM offers, say, incentives or other other ways of encouraging their customers to adopt rooftop solar, that's well within their right to do that, and would be obviously something beneficial in reducing emissions and probably reducing those customers' costs. But I don't think it's within the scope of what they're proposing here as a cost to include.
But I mean, it should have been. I mean, it's interesting to me as a policy matter. The grid mod statute encourages the utilities, doesn't encourages, but it facilitates that if they make investments, there's collection mechanisms they can utilize. but it doesn't seem like, I mean, the grid mod statute does all this work with the distribution system, but then it doesn't capture the point about, well, until you put that distributed energy resource on top of a house or something, and I realize there's more than just rooftop solar as a distributed energy resource, but from most ratepayers' perspective, that's probably the most obvious one. The grid mod statute doesn't really address that part of it, like getting more rooftop solar. And I guess my sense is that's because there's other mechanisms that are out there that are going to assist ratepayers with the cost of that thing. With that, is that accurate? I mean, am I just inventing an answer?
I think from my perspective, customers are already adopting rooftop solar. So whether that's through their utilities incentives or just through market pricing without any other intervention, I can't say specifically, but it's happening. And PNM through this case has shown, and through previous cases, that their system is feeling the constraints of that adoption, of that customer-sided rooftop solar adoption. So it's happening, and they forecast it to continue happening, both in their, I think it's Omni Warner's attachment on their distributed energy future forecast, and through their integrated resource planning, they're foreseeing more and more without them necessarily stepping in to do anything. So I think that these investments are necessary to alleviate what we're already seeing and to just continue to enable more adoption, say, of rooftop solar, but also enabling insights to batteries as customers adopt, residential or smart commercial businesses adopt batteries, or even down to, say, smart water heaters or, air source heat pumps that can be grid connected. There's a whole, plethora of devices that would benefit from a DERMS and upgrading the system to have that insight and control.
Okay, so yeah, that's an interesting point. So electrification more generally, grid modernization is essential. Is that the case, that grid modernization is essential for the electrification movement more generally?
I would say yes. You can electrify end uses, but in terms of being able to plan for integrating them on the distribution system and encouraging load shifting or shedding or other beneficial programs, having grid modernization technologies that PNM is proposing would be critical to maximizing that effort.
Okay, and then last question is from the environmental perspective, is it well established that like a distributed energy resource heavy system leads to emission reductions?
To the extent that the electricity that would otherwise be used is, say, a natural gas plant, coal, or another source of carbon emitting electricity, then yes, it would. So it depends, obviously, what time of day, what time of year that DERMS is operating in to say how much emissions you're going to reduce. But that would be the expectation, is you're enabling greater reductions.
And then Commissioner Ellison asked the question, well, okay, fine, well, we solar achieves that emission reduction goal, but why not, just a bunch of utility scale solar facilities? Do you have any insight into that argument?
Well, I would say we're seeing both, right? I mean, PNM in their most recent IRP is proposing a lot of solar investments, which are utility scale, but that's not you're not going to prohibit customers from individually adopting rooftop solar or from other customers participating in community solar. So I think you would like both to be taking place.
And is that like maximally in the interest of customers for purposes of costs and like system efficiency? I mean, is that the case? The both answer, the distributed energy resources and utility scale solar. I mean, because I guess Commissioner Ellison's argument is, well, look, there's maybe a cheaper way to do this than having distributed energy resources. So why not just do the cheaper route And I have to assume, based on your answer and based on what PNM told us, well, people are adopting this distributed resource rooftop solar anyway. So there's got to be some benefit that so what's that? What's the answer?
I would say that you want both. I can't speak to a specific proportion of utility scale versus customer sided that is ideal. But you'd like to encourage both. And I think as you're looking at grid modernization as a practice, one of perhaps the kind of end members is reaching sort of microgrid solutions where portions of the grid can be islanded in case of outages or other risks. And when you have distributed energy resources, you're able to do that much more easily, protecting, say, neighborhoods or towns when the power at the utility scale goes off. So there's pros to having locally sited or generated electricity, but obviously the economies of scale would favor the kilowatt hour at it, from a utility scale plant might be cheaper, but it doesn't necessarily have all those extra benefits.
And I assume too, like we've had all the problems with, well, not all the problems, but this question about the high costs that come towards the end of the day and the problems with what do you do when the sun starts to set and all the utility scale solar, you'd have to have battery backup, and having perhaps more locally sited battery backups attached to people's houses is more, I don't know, secure and beneficial. Is that the idea?
Well, I mean, that's certainly one, I think, benefit. I think when we're looking at, say, this grid modernization, we're looking at the distribution system. So we're able to provide benefits not at PNM's transmission scale or whole system scale, but individual, say, feeders or transformers, so that utility can encourage, say, adoption of rooftop solar or adoption of batteries at a granular level to resolve constraints that would otherwise need to be resolved through, say, building a bigger new transformer, building out other infrastructure. So it's allowing more solutions to problems that PNM might, run into as we move forward.
Okay, I think that's all my questions. Thank you very much, Mr. Kenny. No one else requested cross. So, Mr. Kenny, thank you for your time today, sir. Appreciate your participation, and you're excused.
Thank you very much.
Examiner, at some point during that, Mr. DeSalen disappeared from the.
Did he?
Yeah, he might be in the lobby.
I don't see him. I see Miss Lane. I'll admit her. Well, if Mr. DeSalen had technical problems, as we sometimes do, and he has any desire to do any redirect with his witness, I'll certainly give him that opportunity when he reappears. But for the moment, we'll just carry on and move on to the Attorney General and their witness, Miss Courtney Lane, who I see is joining us and whose video and audio I'm sure will start shortly. Mr. Lee, if you could swear our witness in.
Miss Lane, if you would please raise your right hand. You solemnly swear the testimony you're about to give in the matter now pending should be the truth, the whole truth, and nothing but the truth.
I do.
Good afternoon, Miss Lane.
Good afternoon.
Do you have what has been marked NMDOJ Supplemental Exhibit 1?
Yes.
And would you please identify that for the record?
Yes, that is my supplemental testimony on behalf of the Office of the Attorney General dated March 1st, 2024.
Thank you. And was this testimony prepared by you or at your direction?
It was.
And is your testimony true and accurate to the best of your knowledge?
It is.
And if I asked you the same questions today, would your answers be the same?
It would.
Do you have any additions or corrections to your testimony?
I do not.
Okay. I'd like to move NMDOJ Supplemental Exhibit 1 into the record, please.
Any objections? NMDOJ Supplemental Exhibit 1's admitted.
Ms. Lane, do you also have PNM Supplemental Hearing Exhibit 14 available? These are your discovery responses to PNM's second set?
Yes, I do.
And same questions. Was this prepared by you or at your direction?
Yes.
And are the answers true and accurate to the best of your knowledge?
Yes.
And if I asked you the same questions today, would your answers be the same?
They would.
Mr. Hearing Examiner, I'd like to move PNM Supplemental Hearing Exhibit 14 into the record.
And just for clarification, that is Public Service Company of New Mexico's objections and responses to New Mexico Department of Justice's fifth set of interrogatories and requests for production of documents.
Let me just verify. I believe that it is labeled New Mexico Department of Justice responses to PNM's second set of discovery to NMAG. PNM
Just
Supplemental Hearing Exhibit 14.
Oh, okay. I'm sorry. I was looking at the my bad. Okay.
Mexico Public Regulation Commission. In the matter of Public Service Company of New Mexico's application components that include advanced.
That's interesting.
Hearing examiner, we're going to object before.
Yeah. Okay. So I'm looking at, okay, Mr. Elliott, you're pointing to PNM Supplemental Hearing Exhibit 14, right?
Correct.
And that is entitled the New Mexico Department of Justice Response to PNM's second set of discovery to NMAG.
It's a PNM exhibit. It may be mislabeled, but I'm looking at this transcription thing popped up. The New Mexico Department of Justice response to PNM second set of discovery to NMAG.
Yes, PNM 14.
Okay.
Yeah.
Yes.
Okay, Mr. Welliger, what's the objection?
Yeah, so this is Ms. Lane's response to our discovery request. I caused these to be exhibits for PNM. If I intend to use some of these in cross-examination, probably only to the extent that I need to impeach Ms. Lane. And I suppose, and Mr. Albright tried this my days are all running together, last week with Ms. Reno's responses to discovery. I will say, if this is a practice that's going to happen where the parties themselves tried to get their own discovery responses into the record because they like them, and it has a chilling effect on PNM asking discovery questions. If I got to tell you, if these discovery responses are allowed to come in, whether I use them or not, or whether Mr. Verheul uses them or not, I won't ask another set of discovery probably to another witness. And I have a fundamental problem with it. To me, it's being used as essentially supplemental testimony on behalf of the witnesses. And I do not think it's appropriate or proper. To the extent I use them and I want to admit them, I can ask and Mr. Elliott can object. If I need them to impeach Ms. Lane, then I should be able to use them. We asked them, PNM asked them, I should be able to use them. But they should not be allowed as as a direct witness or a direct exhibit of the NMDOJ as a means to supplement their testimony. It will have a chilling effect on PNM's wanting to ask any discovery question in the future. And I think it's improper.
Mr. Elliott?
I don't think it's improper. I think that to the extent it discourages anything, it's cherry picking paragraphs or sentences from answers. And the commission should have the full response and full context of a question and a response. And so I don't think it prejudices PNM in any way. They have not only the full responses here as PNM exhibits, but they have their specific questions and specific responses that they want. And so, if they're asking for 2-5C, I think they should have 2-5D as well, the commission. And so, I think PNM is free to ask discovery responses in the future. And if they want the full record of their discovery responses to our discovery questions, I don't see how that prejudices or discourages us from asking questions in the future.
May I respond?
Sure.
To the extent that I ask questions, so let me just back up. The practice of isolating discovery responses to just the subpart that you're asking questions on, that's been a long-standing practice here at the New Mexico PRC. At least, other hearing examiners want the record to be limited to just the response that you're asking questions on. This is why I have one exhibit in here that's just directed at 2.5C because I thought that was the most likely one I would use. I also put the full discovery response in there. I guess what Mr. Elliott's trying to do is to shortcut his own job, in my view. Because if I ask questions about 2.5C and you want 2.5D, you get that in on redirect, and then you can ask for the whole 2.5 to be admitted. This is not something that should be done just as a matter of course at the beginning when the witness is on direct examination. I think it's highly improper, and it would completely chill PNM's desire to ask discovery questions of witnesses.
So, I mean, where my mind on this is, if it's odd to have a party offering. I mean, it's weird to think of adversaries. It's not exactly where we are. It's sort of more a discursive community trying to reach some outcome. But in any case, for the Attorney General to be offering PNM's exhibit as a substantive exhibit is strange. And I guess ultimately it seems to me that the question is like, whatever Ms. Lane said here, and I have not obviously seen this because we don't see your discovery that you all share with one another until the time of hearing, that, why isn't this information just in her testimony? And to the extent to which Ms. Terwilliger is pointing out, well, I asked her something and then now they want to utilize what she said in response. That is, in fact, amending her direct testimony. And I think that does sort of just become supplemental testimony. And I'm not suggesting that in all instances that's necessarily the answer, but for present purposes, I mean, the objection as it is, I don't know what's in this document. So, I mean, I am inclined to say, if it was really that important, it should have been in her supplemental testimony.
May I respond to that?
Sure. Yeah.
Right. Well, this is a discourse, and the conversation does evolve. And in part, it evolves through the questions that are posed. And as we proceed in the course of these hearings, we narrow the issues that are really at the heart of the matter. And PNM asked questions that I thought were worth having answers to in the record. I don't think it hurts the commission in any way to have this information. And we are not here to, this isn't a purely adversarial proceeding. So we offer these in that spirit. I think the question ultimately is there anything that PNM doesn't want to have in the record? It's not gonna, the more information, the better for the commission.
Hearing examiner, if I may.
Mm-hmm.
I guess my response to that is I did not intend, unless it's needed for impeachment, there's several of these to which I do not intend to ask Ms. Lane questions. So if really we are going to admit this, and I would ask for additional time to prepare cross-examination for the entire set of discovery. I don't have questions prepared for every single one of these. I think it's fundamentally unfair to the applicant. While this is not an adversarial proceeding, it is still a adjudicatory proceeding where there are certain processes that are in place, and discovery is meant to, allow us outside of the commission's purview to ask questions, to see to probe, to try to see if we need more information, to see if the witness needs to be impeached, if they've contradicted themselves in some other way. It's not meant to be part of the record unless the attorneys make it part of the record, either through cross-examination or redirect.
Or are you going to try to say something, Mr. Elliott? I heard a
sound. The only thing I would say is if anybody's really at risk here, I think it's the party that's been questioned. So if it's our witness that's at risk of being impeached and we're offering the exhibit, we're assuming the risk. But I leave it to you, Mr. Hearing Examiner. I'm perfectly happy to also do this on redirect if PNM opens the door. I offered it because I think that as I said before, it's only useful to the commission, but I leave it to you.
Sure. No, I appreciate that. And I think it's actually an interesting debate. I mean, I don't pretend to have this all worked out in my mind right at this moment, but just having listened to the discussion as it stands, I mean, and at this time, I mean, my response is this shouldn't come in. And I say that principally because, this whole pre-filed testimony business is very, very unusual, and it changes everything. I mean, like, so for instance, if someone had failed to include their expertise or criteria or what the word I'm looking for, their credentials in their testimony, and like you get to hearing and that's sort of realized, I mean, how do you deal with that even? And that's how, and we have these fights ahead of time because it's efficiency and that's the way the system's designed. So I'm not going to resolve the debate today. I know that much, but at this time, I'll sustain the objection. And Mr. Elliott, as you indicate, some of this can be done on redirect to the extent necessary.
Thank you.
But I don't pretend to have the answer that's the definitive answer for all time. It's all I can give you for the moment.
Very good. I passed the witness. Thank you.
Yeah. So just to clarify, we only have NMDOJ Supplemental Exhibit 1.
That is correct.
And that is the supplemental testimony of Courtney Lane, dated March 1, 24.
Yes, sir.
Terrific. Thank you, Mr. Elliott. We go to Mr. Welliger for 70 minutes.
Thank you. Good afternoon, Ms. Lane.
Good afternoon.
I'll try to take my arguing lawyer hat off here and just ask you questions. Sorry. Okay. In the first phase of this proceeding, you were a proponent that PNM file a benefit cost analysis for its grid mod plan. Is that right?
Yes.
And when the commission ordered PNM to, in fact, conduct a benefit cost analysis, PNM reached out to the stakeholders and the NMDOJ in particular. Isn't that right?
Yes.
And there were multiple meetings?
Yes, I can't recall. I think 2, perhaps.
And do you recall if the NMDOJ was included in the group meetings and had some individual meetings with PNM?
Yes.
Okay. And and I think you state this in testimony, PNM took a number of recommendations from the stakeholders, isn't that right?
Yes.
Including specifically your recommendations, right?
Yes, yes.
And so like PNM exhibit OBW1 to Mr. Warner's supplemental testimony, which is exhibit PNM supplemental hearing exhibit, just for the record's sake, number 1. That PNM exhibit OBW1, which it shows the anticipated outcome of the grid mod programs. Is that right?
Yes, I believe that's in his testimony.
Yep, and the benefits are identified.
Where specifically, or just in general?
I'm in PNM exhibit OBW1. I can share it if that helps you. And if the hearing examiner.
Just like, is there a page, or are you just speaking generally to what is contained within?
Generally.
Yes.
You're free to share, Mr. Welliger, if you want to bring something up. You're posing a question there. Go for it if you want to.
Okay.
Don't have to, but if you think it's useful.
I'll just share. So you recognize this as PNM exhibit OBW1, is that right? I'm on a, wait, okay, I'm not sharing yet. Now I'm sharing. Can you see that?
Yes.
You recognize that as PNM exhibit OBW1 to Mr. Warner's supplemental testimony. Okay. So, and this exhibit also shows the methods used to monetize the benefits.
Yes.
And these were all, if you recall, these were all stakeholder suggestions that PNM specifically incorporated in its benefit cost analysis. Is that right?
No, that's not right.
Showing the benefits, the monetization of the benefits, and the outcomes of the program are not suggestions from stakeholders.
So if I'm understanding your question correctly, the categories of including a benefit description, assumption, benefit, and outcome, those categories were recommended. However, we did not see the full suite of the benefits PNM intended to include in those cases.
But the categories were ones that stakeholders recommended PNM undertook to show, to demonstrate. Yes. Is that right? Okay, good deal. Good deal. Once recommendation included a scenario analysis for AMI, where there was a range of benefits presented by AMI. Do you recall that from stakeholders?
Yes.
And PNM very transparently, and I think this was specifically your recommendation, showed the interdependencies between the grid mod projects. Is that right?
Yes.
And that was your recommendation, right?
Yes, to include them with interdependencies and in isolation.
Okay. And PNM showed the cost and benefits over a 20-year period, isn't that right?
Yes.
And that was a recommendation. Would you agree?
Yes, over the useful life of the measures that were to be installed.
Okay. So going back to something you just said, so generally, you note that not only so PNM showed the interdependencies of the grid mod projects, but one of your concerns is that PNM did not show or demonstrate how the benefits, did not show the benefits of the grid mod programs, the five core grid mod programs in isolation. Isn't that right? That's one of your concerns.
The cost benefit analysis in isolation, which is different than just showing the benefits in isolation.
Okay, fair enough. Do you believe all of the 5 core programs have interdependencies?
No, I do not.
Can you tell me what benefits are interdependent between AMI and the other 5 core programs?
My understanding is that AMI can be deployed on its own, and then FLISR I don't think it's dependent on anything based on Mr. Warner's rebuttal testimony. And then the remaining DERMS, distribution planning systems, and IVVM are dependent. Oh, I'm sorry, Flipsert is dependent on AMI. So it's really AMI that I think is on its own.
Mr.
And
Williger,
sorry,
can I interrupt for a second? I'll pause your time and save you whatever time you need. I just want to ask a question here, because you're at least what you're asking is something that's going on in my brain, I think. I was talking with witness Hawkins about this, and I'm like I'm a DIY guy, mostly because I'm kind of cheap, just doing myself whenever I can. You always save money. And I'm doing this irrigation system, and my little smart controller is this ratio, RACHIO, and it has all this functionality. It'll communicate with, weather stations and like tell you, well, if it's raining out, I won't water your lawn or whatever, because that's not a great idea. And my thought when I was doing all that was like, wait a minute, we're going to be in a world where this irrigation controller is more useful to me than my electric meter, which seems like that shouldn't be. And I understand the point about thinking about the benefits independently or as sort of like a whole, but I guess I'm just like baffled by the idea that we want to stay with meters that are technology of like 20, 30 years ago. I guess I fundamentally don't understand that, whether we look at it as like an independent matter or as a collective, it builds on each other. Like, I guess I need clarification, Ms. Lane, like why on earth should we want to stick with these meters that are pretty useless in comparison to the cell phones we all walk around with all day long?
Sure. So in phase 1 of this proceeding, we supported approval of AMI.
Okay.
Don't have any problems with AMI. Very commonplace across the industry. That's the one area where I agree with PNM that they're lagging behind other utilities. It's really the additional investments beyond that that I think there's more of a choice as to whether you invest in all of them, the timing of the investments, and understanding what the cost benefit analysis is in isolation just provides visibility into sort of those trade-offs between timing and costs and need and things like that.
Okay, I thank you for clarifying that, and I could have sort of stopped talking sooner. Maybe we would have just answered that question. So yeah, so it just strikes me from the user standpoint and the customer, the AMI is the obvious one because it'll tell me about my energy usage, which I don't really know anything about at this juncture, except when my bill goes up or down. And then also one other question, Ms. Lane, on that subject. I mean, it seems one thought I've always had is, a customer now, Ms. Chan said in our most recent rate case, the landscape is changing from a how much, a utility block structure billing system to when, because the constraints on the system are not quantities of generation necessarily, but when the generation occurs. So like, we all know there's an abundance of sunshine and around noon or shortly thereafter, but not so much at 6. So ratepayers could be real confused if they get this bill and they realize like, well, I just have nothing has changed, but my prices have gone up, and they may not be able to fully comprehend how they might reduce their bill unless they have AMI meters that can tell them when they're using energy. Because if the price begins to reflect the reality of an intermittent system, which in theory it will be very soon, 40% coming up, RPS. I mean, it just strikes me as like that's another component to this. Like the customers will need this in order to manage their bills. Is that right?
Yes, although I will say AMI on its own does not provide, that information. It's the customer energy management system, the time of use rates, all the bells and whistles, and other programs and applications that can be tied into AMI, like home area network, things to that extent.
And is the AG behind all of those programs?
We, I believe, supported HON in forgive me, the other cases are sort of being grouped together. It's either EPE or SPS. I forget which one approved it. Our main issue in the previous cases were holding the utility accountable for actually utilizing the AMI to the extent possible to unlock those benefits. And, what are the costs and benefits associated with those other technologies? One concern we've seen in other states is that AMI is deployed and then it's not utilized to provide those customer benefits. So we just really want to make sure that those promised benefits come to fruition.
Okay. Sorry for going on a sidetrack there, Mr. Wilger. Go ahead.
Thank you. So just to go back to where we were, so that the program, you understand when we talk about interdependencies in terms of the cost benefit analysis, you understand how that process worked, I assume, Ms. Lane, and that PNM had certain benefits that it monetized and then it allocated it out to the different 5 core programs. Is that right? Do you recall that?
Yes.
And I think right before the hearing examiner Ryan asked some questions, you said that FLISR was dependent on AMI. I'm going to share my screen if I can.
I thought it was, but I think based on Mr. Warner's supplemental testimony that I'm remembering those tables that he had, FLISR did not show any dependencies. Oh, yeah, that one.
So you would agree this PNM table, OBW4, shows no dependencies for?
Yes.
So for the core programs, the programs that have interdependencies are distribution planning, integrated fault water management or IVVM, and distributed energy resource management system or DERMS. Is that right? Sorry,
did you? Sorry. Yes.
All right. And do you understand that these 3 core programs are interdependent because they're needed as a package to address the interconnection of distributed energy resources?
Yes.
Did you evaluate whether the grid mod plan is intended to facilitate the interconnection of distributed energy resources?
Did I evaluate? I'm not sure. I mean, I reviewed the BCI and in reviewing the phase 1 application, I understand it's PNM's intent to use the resources to do so.
Did you technically evaluate whether any of these programs, or all 3 of these core programs, distribution planning, IVVM, and DERMS, is needed to facilitate the interconnection of distributed energy resources?
I'm not sure I understand the question.
Did you technically evaluate?
What? What? Could you explain what you mean by technically evaluate?
Did you make an assessment that from a technical perspective, PNM does in fact need distribution planning, IVVM, and DERMS in order to facilitate the interconnection of distributed energy resources?
I mean, not from an engineering standpoint.
Okay. And did you evaluate whether PNM can delay the implementation of distribution planning, IVVM, and DERMS without disrupting PNM's ability to continue to interconnect distributed energy resources on its system?
Once again, I'm not sure what's meant by evaluate, but to the extent I reviewed the content of the application and PNM's DER forecast, my understanding is that DERMS may not be needed right away based on the penetration of solar on the system. My understanding is that is when penetration exceeds 60%. So it would really be depending on the feeders that are already at the 35% penetration and seeing about the FLISR and IVM and how those would contribute to those more near-term needs.
Okay, I'm going to go to your response and I'll actually pull up the whole Discovery. One second, I'll share it. Sorry. All right. You see this as interrogatory PNM 2-5, which is the interrogatory PNM posed to you. Is that correct?
Yes.
And your response to 25C states that
Mr. Hearing Examiner, just a quick question. Can you just
Sure.
identify what document we're looking at?
oh, sorry. Yes, sorry. Let me get the exhibit number for you. This is PNM Supplemental Hearing Exhibit number 14.
Okay, thank you.
You recognize that, Ms. Lane, as being your responses to PNM's second set of discovery questions after you filed supplemental testimony regarding the CBA. Is that right?
Yes.
I'm going to go down to 2.5 again. The question in 2.5 is, please state if NMDOJ witness Lane disputes that PNM needs the projects in the grid modernization plan to facilitate interconnection.
I'm sorry, Mr. Welger, you're breaking up. Please state if NMDOJ witness Lane disputes.
Yeah, I'm sorry. I'm probably speaking too fast, Mr. Lee. Sorry about that. Please state if NMDOJ witness Lane disputes that PNM's grid modernization plan enhances. I'm sorry, I'm reading the wrong one. Please state if NMDOJ witness Lane disputes that PNM needs the project in its grid modernization plan to facilitate interconnection of DERs. Please explain your answer fully, stating why or why not. And your response, Ms. Lane, states that you agree that the projects in PNM's grid modernization plan are intended to facilitate interconnection of DERs, but you did not assess to the extent PNM needs these projects to facilitate the interconnection of DERs. Isn't that right?
Yes.
So from a technical perspective, you did not assess the need for these projects. Is that correct?
Yeah, there was no engineering analysis.
Okay, thank you. Do you have a sense of the current pace of interconnection of distributed energy resources on PNM system?
From what was in testimony, I forget the exact percent. I understand 26 feeders were at penetration rates of 35%. I don't recall off the top of my head the exact growth rate.
Did you review PNM Exhibit OBW2, which is the PNM 2040 DER integration plan, which was attached to PNM Supplemental Hearing Exhibit 1, which was Mr. Warner's supplemental testimony?
Yes, I did look at that.
Okay. Are you familiar with the interconnection rulemaking that the commission conducted? Not this year, but I think it was spanned 2022 and 2023.
No, I'm not.
Okay. So you're not aware of the concerns that either PNM has had about its ability to interconnect distributed energy resources, or the commission's concerns about the interconnection of distributed energy resources on PNM system. Is that right?
Well, from what I've heard during the course of the hearing, I understand there's issues with some feeders having, I don't know if backlog's the right term, but I got the general sense of those issues.
Okay. And so since you understood that, so if these feeders that are at what PNM phrases solar saturation, and if the commission doesn't approve the technology in this grid modernization case, do you understand that customers wanting to interconnect their distributed energy resources will have to pay for the same or similar technology to what PNM is proposing in this case in order to accomplish that interconnection?
I don't know enough about that topic.
Are you familiar with, or did you have any involvement in the community solar proceeding in New Mexico's community solar rulemaking or implementation docket? Did you track it, or have you heard about it?
No, I have not.
You don't have any sense in terms of community solar, then, so you don't know anything about the community solar proceeding in New Mexico, is that right?
Asked and
No,
answered.
I don't.
Objection. You might.
Yeah,
Sorry.
I understood you asked and answered.
I was trying to-
Overruled.
Yeah,
It's
I was trying
fine.
to sorry, go ahead.
No, I just overrule it. I understood the answer, and it's clarifying for me listening. So let's go to the next question, Mr.
Yeah,
Ruger.
I was trying to get clarification. I was going to ask a more in-depth question, so I was trying to make sure I understood the extent of her knowledge on that before I asked a more in-depth question. Okay. So just to back up on some of your responses, your recommendation to the commission that PNM should have conducted its cost benefit or its benefit cost analysis for the 5 core programs in isolation is not based on that recommendation that PNM should have done that is not based on your assessment of a technical need for the technologies that PNM has proposed in this case. Is that right?
No, it's about the proper way to conduct a benefit cost analysis.
And in terms of moving on to this, that PNM should have conducted its CBA to estimate the cost of customer-sited solar installations. You believe that PNM inflated its benefits of increased hosting to capacity that results from IVVM, distribution planning, and DERMS because PNM did not estimate the cost of those additional solar installations. Is that right?
Yes, that's correct.
And that's because you think PNM should have accounted for these costs of those installations in the CBA or the BCA for those 3 interdependent programs, right? Distribution planning, IVVM, and DERMS?
Yes, I believe those were the ones that have the hosting capacity benefit. It's whatever programs have that benefit.
And if PNM included the cost of those customer solar installations and it's in that BCA, the benefit cost analysis, should there have been other benefits that PNM accounted for?
Well, I don't know if this is a benefit exactly, but when you account for the cost associated with those incremental solars, you would net out any federal tax credits, state rebate programs. So it's truly just what is the cost to the customer net of any other incentive. So those benefits would have been included.
What about public health benefits?
No, I don't believe so.
What about post-customer non-energy benefits like increased security or comfort for the customers who have customer-sided solar?
Well, in theory, if you want to conduct this cost effectiveness analysis in a manner in which is truly accounting for host customer impacts, yes, you would want to include all of the cost and the benefits to that host customer from the solar installation. So to the extent there's non-energy benefits associated with that, yes, you would want those to be included.
So you believe that, in referencing the National Standard Practice Manual, that PNM, there's several tests that the National Standard Practice Manual has or references in terms of how you evaluate the deployment of DERs. Is that right? Is that basically what the NSPM does?
I'm sorry, for distributed energy resources?
Yes.
Yes, it's been sort of adapted over the years. I know that LBNL report about grid mod BCAs cites it as well. So when I view it in the context of grid mod, it's really just, what are the sound economic principles for conducting a BCA?
But my question is, there's several tests, like the utility cost test, the societal cost test. There's several tests that the NSPM references. Isn't that right?
Yes.
And you think the one closest to what PNM did is the societal cost test?
Yes, based on the tests that are included in there.
I'm going to share my screen here, Examiner. Ms. Lane, this is your testimony, right? NMDOJ supplemental exhibit number 1. I'm sorry, I interrupted you. Did you say yes?
Oh, yeah.
Okay. Let's scroll down here to your. So these are various cost effectiveness tests in your testimony. Isn't that right?
Yes.
And the societal cost test is the last column over here?
Yes.
Okay. And I think earlier you said to me that if PNM accounted for the cost of the host customer equipment, which is the customer-sided solar, you don't think that PNM should have included the benefit of public health benefits. Is that right?
Yes. When I think about behind the meter solar generation, I guess I don't think of public health benefits.
But your own table references that as a benefit under the societal cost test, right?
Yes. So to be clear as to what is in this table, this refers to the impacts that are included in tests. It depends on the type of DER and its application as to whether or not you include an impact in a different case.
Okay. But certainly you did state that the host customer non-energy benefits like increased security and comfort, you would advocate that could be a benefit that should be included. Is that right?
Yes.
But you didn't state, when you said that PNM was missing, let me get your words here. PNM inflated its benefits. You did not note that PNM was actually, there was one benefit that PNM didn't quantify that you even agree could have been quantified for the purposes of IVVM, DERMS, and distribution planning. Is that right?
No, not necessarily. I haven't seen anyone be able to quantify these non-energy benefits of solar yet. We're actually helping Maryland work through developing a jurisdictional cost test right now. And one of the issues we're coming up with is, no one's done a lot of work in the non-energy benefit space for distributed energy resources behind efficiency. So I don't actually have a recommendation for how that would be included here.
Okay, I guess I just want to back up because when I asked you if your recommendations about PNM showing benefits in isolation was about a technical assessment, you said no, it's about conducting a proper cost benefit analysis. Do you remember that testimony just a few minutes ago, probably?
Yes.
So a proper cost benefit analysis, whether you believe or not that no one's been able to quantify these host customer non-energy benefits. If you're basing your assessment on a proper benefit cost analysis, you would agree that's a benefit that should be accounted. Isn't that right?
Yes.
All right. So let's just talk a little bit about the NSPM, the National Standard Practice Manual for Mr. Lee's benefit. You referenced that heavily in your testimony. Is that right?
Yes, I do.
Okay. And the NSPM it's really about, the citation you provided to the version of it, it's about assessing the cost effectiveness of the deployment of distributed energy resources. Isn't that right?
Yes.
And so it's comparing, and when we say DERs or distributed energy resources, we mean energy efficiency, distributed generation, demand response, distributed storage, and electric vehicles, and building electrification. I think those are the kind of the DERs recognized by the NSPM. Is that right?
Yes.
And so the NSPM sort of puts out a framework for whether you evaluate a single DER, like a company, a utility deployed DER as like energy efficiency compared to customer, or a suite of distributed energy resources like any utility sided energy efficiency and demand response versus customer sided. I mean, that's its fundamental premise of that manual. Is that right?
Yes.
And PNM's case is not, PNM has not presented a case to the commission for the deployment of distributed proposed utility side distributed energy resources. Is that right?
It has not, but when it included direct customer benefits of deploying distributed energy resources, then that brings in the scope.
Okay, I think hearing examiner, that's all my questions. I'm gonna stop there.
Okay. Mr. Baker, you requested 5 minutes.
I do not have any questions for Ms. Lane at this time.
Okay, that would be all the interveners. Ms. Lane, as I read your testimony, and then I go and I write my questions as I go. And so I think I was confused at the end of your testimony. So what is your recommendation now in this stage of the case? What should the commission do here?
My recommendation is the same as it was in my testimony, is that PNM refile its BCA to account for the costs associated with the incremental solar that's installed, because they account for the benefits, that they provide the BCA for each program in isolation. They're already partway there. They accounted for the benefits, but it's hard to use that information really because it's not in a context of a benefit cost ratio. And then to correct for some of the double counting that was occurring.
If they were to do that, I mean, is it your expectation that if they were to refile, there's some circumstance in which the benefit cost ratios within the benefit cost analysis change dramatically? Is that your expectation, that there's we can see a circumstance play out where the numbers look really different? Is that your view?
So, forgive me, I forget which, I think it might have been the lister in my direct testimony, where the BCA, if the double counting of benefits removed, it goes from 1.02 to 0.73, so becomes slightly uncost effective. And it's just really hard to know about including the cost of solar, but I do think it would likely have a large impact just because the hosting capacity benefit for DERMS, IBM distribution planning tools was, 70-ish%. It was a massive benefit for all of those three. So, I would think that there would be somewhat of a significant change. It's just hard to know without having seen an analysis.
To the extent to which there are benefits that come to customers. I mean, I guess what I'll just come out and ask it this way. I mean, you know, we're behind in terms of investments in the distribution system and the technologies that exist. They have what appears to be uncontroverted evidence that many of their distribution feeders are maxed out, for lack of a better technical term. I'm sure there's a different one, but I'll just say that. And customers appear to want to incorporate distributed energy in the form of rooftop solar for whatever reasons: cost savings, ethical beliefs, desire to be energy independent. I mean, why shouldn't the commission, just get behind what it appears PNM's customers already want and are spending resources on? I guess that, I mean, that's my concern as I think about the macro level, is if we were to tell them to go out and fine tune their BCA further, are we just getting in the way of progress?
Not necessarily. I think, I'm still of the opinion that DERMS is not something that's needed right now. I believe it was in phase 1 of this proceeding where, subject to check, I think I mentioned it was Pennsylvania, where they were looking at whether smart inverters, that requirement on solar systems was potentially more cost effective than DERMS. And the fact that DERMS doesn't happen until you're at 60%, and they're not there yet. It's not happening until year 6. I think it's important to understand, like, what are the cost of benefits associated with DERMS, especially if it can't increase hosting capacity without batteries. If I'm the commission, I would really want to know, well, how much will it cost to deploy all these batteries in order to require the ability to unlock this hosting capacity, and what is the cost with and without that, what benefits occur without these batteries. Having this transparency and more information about how these work in isolation versus together, and understanding the cost of creating the benefit needed to reach the desired outcome. I think that's just really important. And then to the forecast for customer solar, I think it's important to assess just the cost effectiveness of that DER implementation along with grid modernization. For example, California has a statute that says utility spending on DER integration should be pursued to the extent that DER growth is cost effective. So, states are sort of looking at this in a holistic picture. It really just comes down to the fact that these are large ratepayer impacts. Especially if the state is trying to meet its carbon goals, there will be other costs put on the ratepayer to meet that long-term carbon reduction goal. There's only so much room on the bill, especially if you want to shift to electrification. We have to balance which of these investments is needed now, what's the most cost-effective option, and you can really only get that from a more granular analysis.
Okay. Those were all the questions I had. Mr. Elliott, opportunity for redirect.
Thank you, Mr. Hearing Examiner. Ms. Lane, you were asked about question 2.5, or PNM. This is from PNM's Exhibit 14.
Yes.
Okay. In question E of that set, or of that series of questions, you're asked if grid mod is not used to ready PNM's grid for DERs. Please state if you agree or understand that interconnecting customers are more likely to have to pay increased cost to interconnect their DERs to PNM's distribution. and you responded that you didn't have the information on PNM's practice of charging customers for interconnecting. Is that right?
Yes.
And would that be a scenario, or could PNM have modeled that in their cost benefit analysis?
Yes, I suppose one of the benefits, and I would have to look at this in the full context of the BCA to understand how it all flows together. But if that is a cost that's avoided, the avoided cost to the customer could have been included.
And Ms. Terwilliger asked you about your recommendations that PNM conduct the BCA or CBA, as we're calling it, for each of the 5 core programs in isolation. That was based on best practices?
Yes, that comes from the LBNL DOE Synapse report. I forget what we're calling it too, but it was an appendix to either Mr. Warner or Mr. Shields's rebuttal testimony. And in there, it speaks to conducting a BCA for each component in isolation, as well as together in buckets accounting for interdependencies.
And in your conversation with the hearing examiner just now, you were talking about timing. So would deployment timelines be a scenario that could have been modeled? Alternative deployments timelines?
Yes, you could assume a certain technology was deployed earlier or later and conduct it that way.
And Ms. Terwilliger also referenced your meetings with PNM. During those meetings, did you recommend that PNM conduct any of those analyses in isolation?
Yes.
And just my last question here is, these analyses, they're for the policy decision makers, correct?
Yes.
So what's the benefit of having that sort of alternatives analysis in the CBA?
It provides more information to make an informed decision.
Thank you. I have no further questions. Thank you, Ms. Lane.
Thank you.
All right. The next, Mr. Elliott, no further witnesses from the AG, correct?
No, sir. Thank you.
Okay, Ms. Lane, thank you for joining us today and appreciate your participation.
Thank you. Bye.
Why don't we're going to go to Mr. Albright, and why don't we get the witness in, but then take like a 10-minute break, and then we'll just come back and finish. Is that acceptable to everyone?
Certainly acceptable to the county, Mr. Hearing Examiner.
Yeah, we'll just get the witness up and have him sworn in and do all that, and then we'll because we got by my sheet here 60, 20, 40, so 2 hours. Yeah, so we'll have to take the break. Is Miss Reno here?
I believe so.
And she's in the waiting room. I'm gonna admit her. There we go. She's coming in. All right, Ms. Reno, can you hear us?
Yes, I can.
Great. Mr. Lee, could you swear in Ms. Reno?
Ms. Reno, would you raise your right hand, please? You solemnly swear the testimony you're about to give in the matter not pending should be the truth, the whole truth, and nothing but the...
Yes, I do.
Go ahead, Mr. Albright.
Thank you, ma'am.
Thank you, sir. Ms. Reno, would you please state your name and address and business for the record, please?
Yes, my name is Maureen Reno. My address is 19 Hope Hill Road, Derry, New Hampshire, and I am an economist and principal and owner of Reno Energy Consulting Services, LLC.
And you have appeared before this commission before in other proceedings, correct?
Yes, I have. I have participated in a series of rate cases involving this company and a couple others. I've also been involved in a series of other proceedings involving this company, including decoupling, also the merger proposal or the acquisition proposal with Avangrid.
But you were not involved in phase one of this proceeding, correct?
No, I was not.
Okay. You have before you what has been marked as Bernalillo County Supplemental Hearing Exhibit 1.1. Your corrected supplemental testimony of Maureen Reno in response to cost benefit analysis on behalf of Bernalillo County. And that was filed April 22, 2024. Was that document with its correction prepared under your supervision, correction, or direction and control?
Yes.
And if I were to ask you the same questions today as were asked at the time you prepared your testimony, would your answers be the same?
Yes, they would.
And that's with the correction that was made on page 19, correct?
That's correct.
Mr. Hearing Examiner, at this time, I move for the admission of Bernalillo County Supplemental Hearing Exhibit number 1.1.
Any objections? Well, wait, Mr. Albright, is there going to be like a 1 point? I'm assuming I haven't looked at Dropbox, but there's going to be a 1.2.
There is, then that is the errata. So I'm going to introduce that so they go together. The 1.1 was submitted without the line through so that we had a clean copy of that. I am going to introduce 1.2, which was the errata to it.
Well, I think just because nobody else in the proceeding has used the point, it might just confuse somebody if they're looking at it after the fact. So let's just call it Exhibit 1. If that's all right? Burnco Supplemental Exhibit 1, and then the errata to Supplemental Exhibit 1, if that's acceptable, instead of 1.1 and 1.2, because there's no other document that would come in that's a 1 point whatever.
Well, Mr. Hearing Examiner, I'm fine with that. The only concern I would have was that when we were discussing making the errata before, you had mentioned you were going to keep both the original and the 1.1 on the Dropbox.
Yeah, that's fine. But if it just has a different title, just calling it, there's Supplemental Exhibit number 1 and then Supplemental Exhibit 1 errata. That would be the differentiation, in my mind anyway. I'm just not sure. I haven't 1.1 and 1.2. There's no other exhibits in the case that are 1 or 1 point whatever. So I'm a little hesitant with that.
Understood. We just didn't want to have to renumber all of the other exhibits as well.
Are there others you're going to seek to admit as well?
No, not at this time anyway. I mean, perhaps later on redirect or during, but those are going to be the only two. Is going to be that, and then the errata that was submitted separately, errata the supplemental testimony, which we have labeled right now as 1.2.
Yeah, let's just call it Supplemental Hearing Exhibit 1, Burnco, and then Supplemental Hearing Exhibit 1, errata, Burnco, and then we'll just leave it at that for simplification.
I'm fine with that, Mr. Hearing Examiner.
All right, great. So then, are there any objections to the admission of Bernalillo County Supplemental Hearing Exhibit 1? No objections, so supplemental hearing exhibit 1 will be admitted.
Thank you, sir. And Ms. Reno, you have before you what has been identified as the errata to the supplemental testimony of Maureen Reno in response to the cost benefit analysis on behalf of Bernalillo County. Do you have that document in front of you?
Yes, I do.
And was that document prepared under your supervision, direction, and control?
Yes.
And was that errata correction that you made to your testimony, which was just admitted as Exhibit 1?
Yes.
And the reason for the change? Reason for the errata?
Yes, I had to make a correction to the description on page 19, line 1. Originally, it had return on equity of 6.47%. That isn't accurate. Must have been an editorial change. And so I deleted on equity and inserted before return, rate of return. So that line now says significantly higher than PNM's currently authorized rate of return of 6.47%.
Okay. And were there any other changes or corrections to your testimony?
No.
If I were to ask you the same questions today as were asked at the time you prepared your errata to the testimony, would your answers be the same?
Yes.
I move for the admission of the supplemental hearing exhibit, the errata to supplemental testimony of Maureen Reno in response to the CBA, the cost benefit analysis.
Any objections? None. And again, just for clarity of the record, we'll just refer to this as the errata to supplemental hearing exhibit 1.
Thank you, sir. And I present the witness for cross-examination when we return from the break.
Yep. And just before we do that, Mr. Verheuel, do you believe you'll use the full hour?
I do not.
Okay. Well, I do feel like we have to have a break still. Just give our court report. We've been going for an hour and a half. So we'll be back in 15, let's say 2:15. See you then.
Thank you.
All right, it's 2:15. Mr. Lee will go back on the record. We've just returned from a short break. The witness was presented by Bernalillo County and sworn in. And we will now turn to requested cross-examination time. And PNM, Mr. Verheuvel, you requested 60 minutes, so go ahead, sir.
Thank you, Mr. Hearing Examiner. But PNM is going to live up to your characterization as being very efficient with cross-examination, and we're going to waive cross-examination of this witness.
Excellent. Let's see, anybody else? No. And I don't have any questions for Ms. Reno either. So I will say only that I appreciate your participation, Ms. Reno, and thank you for filing testimony and appearing today in our supplemental proceeding.
You're welcome. It was my pleasure.
Okay, Mr. Baker, I have you up.
Okay, you'll have to help me. I'm not quite sure how to present myself as a witness.
Yeah, I gotta go into. All right, so you should have shared whatever you intended to admit in today's proceeding onto Dropbox. I'm just trying to find that. Is it? Okay, so I see Baker supplemental hearing 1, 2, 3, and 4.
Correct.
Baker testimony in response to CBA, Dan Baker. Baker response to PNM's first set of interrogatories. Are you seeking to admit all these documents right now, Mr. Baker, or just?
From what I understood from our previous discussion there, is that at this time we just introduce my testimony and then the other stuff is as needed. Is that correct?
Yeah, well, I mean, right. So you have cross exhibits you can utilize, and if those are, I mean, typically you would have testimony, and then as you've seen, the parties will prepare exhibits to supply to the tribunal during the cross-examination of witnesses. But my guess is you're probably likely just looking at the testimony of Dan Baker here to submit now.
Yeah, I think.
Unless you want to do something else, Mr. Baker. I mean, it's kind of up to you what you want.
No, I'm fine with just starting the testimony and see what PNM asked me. Or you ask me.
Yeah, okay. Well, all right. So I'm looking at a document here, Mr. Baker, shared on the Dropbox system, identified as
Exhibit
Baker,
1 is my testimony.
Baker Supplemental Hearing Exhibit 1. The title of the document is Testimony in Response to Cost Benefit Analysis of Daniel T. Baker. The date is February 27, 2024. You're familiar with this document, Mr. Baker?
Yes, I am.
And I presume you wrote this document?
I did.
And if you were asked these
I'm
questions.
sorry, Judge. Sorry, Judge. Do I need to swear the witness?
Oh, yes, you do. Thank you, Mr. Lee. I appreciate it.
Yep. Sorry.
Mr. Baker, would you please raise your right hand? You solemnly swear the testimony you're about to give in the matter not pending should be the truth, the whole truth, and nothing but the.
I do.
Thank you.
All right, so Mr. Baker, you indicated you're familiar with this document. You indicated that you wrote it. And the question I was going to ask you next was, if I were to ask you these questions to which you have provided answers, if I ask you them now, would you provide the same responses?
Yes, I would. Thank you.
Are they true and accurate to the best of your knowledge?
Yes, they are.
Do you have any corrections to make to any of these answers?
No, I do not.
Okay. Then what we'll do is I would move, I propose accepting into evidence Baker Supplemental Hearing Exhibit 1. Are there any objections? Okay, Baker Supplemental Hearing Exhibit 1 is admitted. And at this juncture, Mr. Baker, you will hold off on the other exhibits?
Correct. And I if that's the appropriate time, I tender myself to your questions.
And just so you're aware that there may be no questions and someone may not actually ask you anything, so there may not be any other opportunities to admit any of these other documents. You're aware of that, right?
I'm aware of that. I do have a question about, I guess if there's no questions, then I also don't have an opportunity to redirect, right? I was trying to figure out how that works.
Wait, you'd have to redirect yourself. I'd have to think about that for a little while, Mr. I think, I think on some level, this is what you're really dealing with is it functioning as a pro se intervener in these proceedings is very different than having counsel represent, because there's the party and then there's counsel for the party and there's all that. So you're just Mr. Baker.
It's pretty wild from my end, I'll tell you that. And the reason I asked that question is, as we've been going, I've heard a few questions from you that I could probably answer or help answer, but the only way I would have to bring them in would be in redirect. So it's up to you.
Well, no, we can't. In some ways, this is not just a free flowing conversation. There are rules and people plan, and so in some regards, like you do actually have to anticipate what the questions will be and provide answers to them in your testimony. So if I don't ask you the question, it does basically foreclose your ability to, like, you don't get to come and just kind of talk, right?
Right.
And unfortunately, that's not the way it works.
I get that. That's in the brief, right?
Yeah. Right. And if there are things you feel can be clarified in briefing, right. This is your factual record. You're submitting testimony. You have the opportunity to cross the witnesses, provide fact testimony. And then the next step in the proceeding is you make arguments based on the facts admitted. And some facts, I understandably, we're not going to evaluate every fact that underlies all of this. Some of it's just presumed. So if you want to make assertions that are, I don't know, predicated on common knowledge or whatever, I don't know what it is you wanted to point out, but you can do that in briefing too.
Yes. I think I'm good with that and tender myself for questions, I believe, from PNM or?
Yeah, well, that's the first folks. Mr. Verheuls indicated request 20 minutes, and I will just say that supplemental hearing Baker 1 is admitted. If I might have done that already, I don't recall, but just in case I didn't, I'll say that. And we will turn to Mr. Verheul, who requested 20 minutes.
Thank you, Mr. Hearing Examiner. PNM has no questions from Mr. Baker.
Very good, and I have no questions for you either, Mr. Baker, so look forward to receiving your brief. And
okay. All right, thank you.
Yep. Staff, Mr. Borman.
Yes, I'm going to be calling Mark Tupler, and in fact, since this has gone a little quicker, I know he's watching on the YouTube. I want to get him in.
Yeah, I'll keep my eye on the waiting room.
Okay. Texting him right now.
And there he is. I've just admitted him.
Good morning or good afternoon, Mr. Tupler.
Yes, sir. Good afternoon.
Could the witness please be sworn?
Oops, I think you might.
You're on mute.
Mr. Tepler, you solemnly swear the testimony you're about to give in the matter not pending should be the truth, the whole truth, and nothing but the.
Yes, sir, I do.
Thank you. Mr. Tupler, by whom are you employed and in what capacity?
I am a senior economist employed by the New Mexico PRC in the utility division.
As part of your duties in that position, did you review the application of Public Service Company of New Mexico for authorization to implement its grid mod proposal?
Yes, sir, I did.
And as part of those duties or part of doing so, did you prepare or participate in preparing supplemental testimony for this proceeding?
I did.
Okay, and do you have a copy of staff supplemental hearing exhibit number 1?
I have it in front of me.
Okay, can you identify that document?
Yes, sir. It is my supplemental testimony in this case filed on March 1st, 2024.
Was staff supplemental exhibit number 1 prepared by you or under your supervision?
Yes, it was.
Do you have any changes or corrections to that testimony?
No changes.
If I asked you today the same questions as are set forth in staff supplemental exhibit number 1, would your answers be the same?
Yes, they would.
And are those answers true and correct to the best of your knowledge?
Yes, sir.
And do you adopt staff supplemental exhibit 1 as your sworn testimony in this matter?
Yes, I do.
Thank you, Mr. Tupler. Mr. Hearing Examiner, at this time, I move admission of staff supplemental exhibit number 1.
Any objections? Staff supplemental hearing exhibit 1 is admitted.
Thank you. Mr. Tupler is available for examination.
Ms. Beatles, you have 10 minutes requested.
Yes, but I don't need them. Thank you, Mr. Hearing Examiner. I have no cross.
And Bernalillo Crowney, you requested 5.
Yes, sir. I just have a couple of questions.
Sure.
Good afternoon, Mr. Tupler.
Thank you. Good afternoon to you as well, Mr. Albright.
I'm representing Bernalillo County in this proceeding and just had a few questions I wanted to follow up on with regard to the testimony. I'm not asking for an interpretation of the statute, but the statute with regard to the application for grid modernization projects allow for a tariff rider or in base rates with regard to the implementation. Does staff have a position as to a recommendation for the commission as to whether or not it should be a tariff rider or should be included in base rates for the grid mod program?
Well, and I answer this as a non-attorney, if the statute allows either or, my position would be that the company makes that decision. However, if I had to choose one, it seems that for transparency reasons, a rider might be a better way to see it.
Okay. And I asked Mr. Kenny earlier today with regard to some questions involving reports or follow-on, and what kind of reports would be most beneficial to staff? Periodic reports if the grid mod is implemented.
Yes, sure. I think a smart basic report would be a variance analysis of projected budget items versus their actual items after a year's worth of information or operation. And then, of course, with a variance report like that, maybe a certain level of detail as to the reasons for the variances.
Okay, and this proceeding obviously is separate from the rulemaking proceeding. So how do you see the outcome from this proceeding being integrated into the rulemaking proceeding, the 89 case?
Interesting question. I'm not certain I could answer that. I don't know how the results from this case will be moved into the subsequent case, the rulemaking.
Is it something that staff would be willing to look into with regard to the potential impact?
Makes sense. Yes, sir.
Mr. Hearing Examiner, I have no further questions for Mr. Tupler. Thank you. And thank you, Mr. Tupler. Appreciate the responses and potential insight.
Great. Thank you.
Mr. Bruno, you requested 20 minutes of Mr. Tupler.
I think I'm gonna skip that today. Thank you.
Okay, then that concludes the presentation of the evidence. Or well, I guess I should say, Mr. Borman, did you have any redirect based on Mr. Albright's questions?
Thank you, Mr. Hearing Examiner. I do not have any redirect.
Great. I don't have any questions, Mr. Tupler. Thank you very much, Mr. Tupler, for coming. Appreciate your participation in the hearing. Have a good afternoon.
Thank you, sir.
All right, with that, we have come to the conclusion of the presentation of the evidence in this case. I can ask the applicant, Mr. Verhule, you guys, PNM has supplied everything it wishes to supply in this supplemental hearing, is that correct?
Sorry, I was muted. We have. Thank you, Mr. Hearing Examiner.
Terrific. Right, so we have briefs already in this case on the first phase of the proceedings. I mean, as far as actual briefing schedule here, I mean, before answering like when, which I would suggest we just go by the rule, the first question would be like, well, what do we supply? I mean, obviously, I think there should be an opportunity for the applicant to tell the commission, hey, we filed our brief, we explained to you why we think you should approve this application. You asked us for the BCA, we gave it to you. And then to the extent to which any of the development of evidence now is further reason to improve it. I think, as I say, Mr. Verhule, I think the applicant, you guys can file your brief and say to the commission, here's how the BCA supports what we said in the first instance. That to me seems like an obvious one. And then as to the parties, my view would be, I'd like to know, what would be most interesting to me from the interveners is if the BCA modified a party's view on any subjects and how. That also strikes me as kind of obvious. We directed them to go out. So to the extent to which you filed a brief and you said something and now you have a change in position because of what was filed in the BCA, we'll tell the commission about that. I should not surprise you to know that the commissioners obviously have thought about this. Commissioner Ellison participated meaningfully here as he did in the last, and I'm sure they have lots of thoughts about the subject as well. So as to the actual submission time for those briefs, I would just, I don't want to have to figure it out now. I would just put into an order. We'll just go off the rules and we'll just figure out what those days are by counting. I'll just work that out, the math later, and submit that in an order if that's acceptable to the parties. And then, I understand the PNM's desire to have a timely resolution, and I can assure you, I know that this is a top priority for the commission, and we will get it completed as efficiently and expeditiously as is humanly possible. Mr. Bruno, I did notice you filed a motion. I should probably address that before we wrap up.
Yes, sir.
What is the motion?
It's just a request to take administrative notice of some rules recently posted by the state licensure board.
I'm not even sure what to do with the motion that's filed that late. I mean, I suppose the other parties can have an opportunity to respond, and I won't even set a timeline on that. I'll just leave that out there. And I haven't read the motion. I don't know what's in it, so I don't want to have to make a determination about it at this time. Mr. Verhul, were you going to try to chime in?
Only to the extent that my recollection is PNM is the only party that, at least publicly, opposed the motion. So if you wanted a response from us, I suppose you can rule on it on your own without our response. But if you would like a response,
no, I won't commit you to that, Mr. Verhul. Only do so if you think it's necessary. Obviously, the question, I think we've already sort of touched on this in the pre-hearing motions, and what is the bearing of that particular set of administrative principles and whatever these documents might be to this particular grid mod proceeding as a matter of law. I don't know. So
I should add, those are new. Those FAQs only appeared on their website this month, so it's new information for that has bearing on the legality of some of this case.
Yeah, I understand your position on the subject, Mr. Bruno. All right, so I will just review that motion and address it as necessary. PNM, you don't need to do anything at this point. If I do want a response once I've had opportunity to read that motion, I'll say so. And if I do not, you can just interpret that as no response needed.
Understood.
Anything else from anyone?
Mr. Hearing Examiner,
yes.
Is there any expected time for full hearing transcripts to be filed, do you think?
Yeah, 10, is it Mr. Lee, 10 business days? Is that the idea, turnaround?
Yes, sure.
Mr. Lee is pretty good too. He's not obligated to move faster than 10 days, but he's a very effective and competent court reporter. So we frequently get stuff from him faster. And this wasn't a super long hearing, so I would think 10 days is the outer bounds, Mr. Verhul.
Excellent, thank you.
All right, well, that concludes the public hearing for case 22-00058. Thank you to all the parties and all of your witnesses who participated. And that's all. Have a good afternoon,
Mr.
everybody.
Hearing Examiner.